we can go live.
Yeah. Hi, good afternoon, everybody. This is Chandra.
So I'll do some introductory remarks.
Yeah, sure.
I'll hand over to you. Don't worry about that.
We are live.
Hello and welcome welcome to day 2 of MediaNama's discussion on decoding the data protection bill. Today we're going to discuss 3 important topics: the construct of the data protection authority and its implications for users. I'm really looking forward to this particular session because I think we've got two very, very good speakers, and it seems I'm also joining the panel now to discuss regulatory design and function. We have 2 sessions to follow, which are at the heart of any privacy and data protection law, about how users are going to engage with the data protection bill and how their rights will be impacted, and how government access to data will impact user rights. We'd like to thank Google, Flipkart, Meta, and Star India for the support for this discussion, and we're also thankful to ADIF as our partners for this discussion. Without further ado, I'd like to hand over to Mr. Chandrasekhar from KNS Partners to chair the first session. Over to you, Shekhar.
Yes, hi, good afternoon, everybody. And thank you for making it. And today's session promises to be really, really interesting because we have 2 star speakers, Alok Prasanna and Renuka Sane, both of whom have got a lot of experience on regulatory design. So it would not be an exaggeration for me to say that getting this piece right is probably the key to getting the entire regulation, data protection regulation right. So the design of the DPA, how it pans out, how it functions, how it will influence the various stakeholders, that would be most critical for the success of this program. So when a regulatory design is done, the regulator has to first look at what is the primary constituency, what is the primary benefit which they are trying to protect. Are they trying to protect an asset? Are they trying to have level playing field? Are they trying to protect consumer interest? Are they trying to protect any kind of predatory approaches? So these are all the factors which a regulator has to take into account, and these are the factors which the legislation has to take into account while designing the regulatory framework. So without further ado, I would request first Alok to say a few words about himself, and then give us the top of his mind thoughts about the current design of the DPA as it stands. I would then move over to Renuka. Over to you, Alok.
Thank you, Mr. Chandrasekhar. Just to talk a little bit about myself, I'm Alok Prasanna Kumar. I'm one of the co-founders and currently a team lead at the Vidhi Center for Legal Policy. And I've been with Vidhi since the start, which just literally started in my living room in 2013. And before that, I was a practicing lawyer in the Supreme Court. I used to appear for the government, union government mostly. This is basically my background as a lawyer professionally. Just to start on my thoughts, very brief top level things. I want to say about 3 things, and I'll elaborate on them as the course of our discussion goes. The first thing is, and I want to focus on the report of the Parliamentary Standing Committee. It doesn't seem to have put too much thought into the ideas behind the regulator. It goes directly and jumps into the actual provision saying, oh, we can tweak it like this, we can tweak it like that, we can add this, we can add that. Whereas it has at least some thoughts and some thinking about the role of data in the economy, the importance of data protection and so on in the first 40, 50 pages or so. But when it comes to the question of what we should do with the regulator, it jumps straight into we should do this, we should not do this. And to me, and this is the first point I want to make, it highlights a lack of serious thought behind some of the changes that it proposes. In a sense, these changes seem to come a little bit out of nowhere, and we're not particularly clear what it's trying to address. That's as regards the data protection, that is regards the report of the Parliamentary Standing Committee itself. The second point that I sort of want to make is that independent of whatever that report says, a law can only help design a regulator to function as intended to a certain extent. However well the law is drafted, however well the rules are framed, they can only go to a certain extent in ensuring that a regulator functions independently in an accountable manner, in a transparent manner, and is effective at what it's doing. So I just sort of want to highlight, and lawyers are not known for this, but I want to highlight that the law has its limits here, but there are ways we can address that. Finally, and the third thing that I sort of want to highlight, and it's a little bit of a follow on from the last point which I made, it's about effectiveness. I counted in the legislation about 14, or actually 15 different functions given to the Data Protection Authority. No regulator is going to be able to perform these 15 functions on day one, right? There needs to be a serious conversation on what should be the main focus, or where should the Data Protection Authority focus its energies. And unfortunately, I'm not seeing enough discussion on that. I mean, a lot of functions are being mentioned. A lot of people are saying it should do this, it should do this, it should do this, it should do this. If you look at the Act itself, it gives 14. And now, thanks to the Parliamentary Committee saying, oh, it should also look at non-personal data, it's effectively a different function, it's a 15th function. And I think that will cause a problem unless there is a clear sense that this is what we want our Data Protection Authority to do from day one. So I'll leave it at these three slightly high-level points. I'll go into some more detail as in when the discussion proceeds.
Yes, so I will now move to Renuka. Renuka, request you to introduce yourself and give us your top of the mind thoughts on the design as it currently exists before we dive down to the next level.
Well, thank you, and thank you, MediaNama, for having me here. I'm an associate professor at NIPF, and I largely started once you start worrying and looking at how financial sector regulators are behaving, you can't but help think about questions of regulatory design in general. And I think that has brought me to this space. Talking about the points on DPA and also kind of reacting a little bit to what Alok said, I agree that there isn't much thought given to the design of the DPA per se. And some of my concerns are about regulating the regulator, so to speak. So, there are a few things that are given. So one is that the expanse of DPA is, far bigger than any other regulator that we have seen in India. And this means that the responsibilities on the DPA are higher, and the chances that the DPA may misbehave either intentionally or sometimes unintentionally, because it is also constrained in terms of capacity with its regulated entities, is also a lot higher. Typically in India, whenever we have set up a new regulator, we have said that, let's go by the experience of our existing regulators, and then let's just model this regulator on the basis of how SEBI is functioning or how CCI is functioning, the other regulators in India are functioning. And my worry is that if the DPA is modeled along those lines, then all the problems that pervade the existing regulators in terms of how they function will also pervade the DPA. And while there are costs of bad functioning at the RBI or the SEBI or any other regulator that you might think of, the costs of doing this is much greater in the DPA space because the mandate is much bigger. So that's one. Let's not immediately jump to modeling this regulator on the basis of current regulators. So what that brings me to what is wrong with current regulators. And I'll just sort of give a couple of high level points and then maybe we can discuss them later, is that the governance structure of the regulators itself and the constraints on the regulation. In OECD countries where we see slightly better behavior, many of the things of what regulator cannot do, how it should behave, how it should frame regulations, how it should do enforcement, are codified in the US, for example, in the Administrative Procedures Act. Okay, and or in the UK, there are more detailed rules or specifications within the legislation itself that constrain the regulator. In India, we don't do all of that, and that has had adverse consequences on a lot of the decisions that the regulator has taken in the past. And I expect that if we copy this design there without all of these constraints, then we will have similar problems in the data protection space. And that is something that I worry about. And so in the context of the design of the DPA, my number one worry is the constraints that you place on the regulator itself, or the obligations that you place on the regulator itself in terms of how it should behave, because that has implications for the welfare of the regulated entities and cost of doing business. So I'll stop here and then maybe I can go into a little bit more detail about the things I worry about.
Yeah, so thanks, Alok and Renuka. You have sort of framed the initial problem. And Nikhil, what is your view on this? What are your top of the mind thoughts on the problems on the initial design?
Thanks, Shekhar. So my core idea or core thought here is, can the DPA inspire confidence in citizens? Can it inspire confidence in users that if they go and file a complaint with the DPA because their privacy has been violated, will they get justice? Is this, will the DPA be responsive? Will it have capacity to respond to my complaint? If hundreds and thousands of others are also filing theirs, will if I file a complaint against a big fish, let's say the Election Commission, like it happened in the Philippines, where the first case that was picked up was against the Election Commission of Philippines. So if there is a big fish, if it's the UIDAI, if it is the Ministry of Home Affairs, or if it's, let's say, any large fintech company that has abused my data and sort of profiled me in a manner and, let's say, denied me a loan or sold my data to someone else, will large players will I feel confident that my case will be picked up, and will I get any form of justice from the DPA? Will regulations be created to protect me from either large government or big tech? And to the other end, will the government feel that it has something to worry about because it's violating privacy? Like we saw earlier in 2013, 14, 15, all sorts of Aadhaar data was published by departments online, and none of them really were taken to task for it by the looks of it. There are there's constant pressure. Like, just as a random example, a golf course in Delhi was asking members to email them their photocopies of their Aadhaar or give their Aadhaar detail because they want to do Aadhaar authentication for people to play golf. And for me, that's a privacy violation and a violation of the Aadhaar Act. And so where will I get justice? And will people actually start worrying about collecting all sorts of data and profiling? Will governments worry? Will companies worry? So that's my core thing. Do we have a design of a DPA that will inspire confidence in citizens so that they can assert their rights? And by the looks of it, given the kind of control that the government has over the DPA, both in terms of policy and directions, I don't think so.
Yeah, so it's good. Thanks for your thoughts. And now we have a frame of reference as far as the major issues and the major concerns are concerned. So I'll now like to go to each one of you, starting with Alok. Now, given that this is the problem, what would be your top 5 suggestions for a quick fix? Like, for instance, the more representation from, say, the corporate sector, or more representation from judiciary or from the civil society. That would be one. So what would be your top 5 recommendations? We can go by the 90-10 rule, a small recommendation which has a big impact.
I'm very wary of quick fixes. Let me put it out there. At least in something like this, I would I would say these are my 5 suggestions on how things can be improved. I don't know if there'll be quick fixes, because we should be wary of quick fixes, because when we are setting up an institution, it's a bit like, if you've all seen that ad when that man decides choosing between cheap cement or good cement and stuff like that. A quick fix can become like a cheap cement that will get you your work done quickly, but you may live to regret it afterwards. One thing I would start with right now is to sort of widen the scope of people who are in the appointment committee. Now, the issue is, and even this was a problem with the 2019 version of the bill as well, it limited it only to 3 secretary rank officers. Now, what there was cabinet secretary, a law secretary, and MeitY secretary, if I'm not mistaken. Now it has just been expanded to, in a somewhat bizarre way. And I say bizarre because I cannot for the life of me fathom, and no disrespect to anyone, I cannot fathom what the director of the IIM will bring into this discussion. All right. If we want any academic to be involved, I can imagine the triple ITs, the Indian Institute of Information Technologies, they may have something to add. Maybe someone who is sort of, you would rather go by their qualifications rather than their designation, right? You're not appointing for an academic position. If you want to bring in place somebody who has in-depth knowledge of the field, you should be saying, and it's okay even if the government picks everyone on that committee. I don't mind, because at the end of the day, it's easier for the government to just pick up a list of 6 and say, here we're appointing, rather than trying to do it indirectly by getting people who will only appoint people the government likes. So my point is that, if the government is genuine, right? If the let's say the legislature is genuine about saying we want there to be more experts, and this is the weird thing about the committee report. They say we want experts, but their idea of experts is bizarre. And again, IIT director, again, no disrespect, that person is in that position more likely because of their administrative experience rather than because they're currently doing some cutting edge research in the field of data science, right? Or have some knowledge and understanding of how data protection authorities in the world work. And not to diss on any one of them, but they may be asked to do something they're not particularly equipped to do, which is identify an expert who can be on this committee. Likewise, the Attorney General for India. Now, the Attorney General for India is overworked on a daily basis. This is a gentleman or a woman who not only has to handle a bunch of cases in court, but has to advise government, is sometimes part of cabinet meetings. There were a million things to do. If you ask them, in addition to that, why don't you apply your mind to an area of law you may not generally be familiar with, to identify an expert in the area of law, it may be a task slightly beyond them, right? Because if you look at it today, most of the people who are concerned with issues of data protection, 95% are those working in law firms. There may be 5% of litigating lawyers who are actually going to courts and fighting some of these cases. And as the Attorney General, you almost never interact with law firms. You will almost generally see lawyers appearing in court. So you may be seeing the wrong end of the profession to decide who is the legal expert here. So I would say that whole composition of the committee, I mean, irrespective of who appoints that committee, if the government wants to pick all 7 people, fine, pick 7 people. But we should have a clearer idea of what they're bringing to the table. That is simply not being done. Second thing is that half measures don't work. If the government doesn't want this DPA to handle issues like what Nikhil just mentioned, right? Go after government agencies which might be misusing data or causing a breach and so on, they should come out and say it. What's the point of this halfway measure by saying, oh, okay, this will also apply to government departments, but for them, we will allow the action to be done internally. And then if it doesn't work, we'll think about external action and so on. Because what that does to me is to sort of leave this authority in a very confused place on day one. Am I supposed to be looking at, hypothetically, just taking off from what Nikhil said, am I supposed to be looking at the leak of, say, Election Commission data, or am I supposed to be looking at whether an Indian startup or an Indian company is misusing data or scraping of data it's not supposed to do, collecting data incorrectly, data breaches, and so on? This will sort of confuse it in some instances. And if you wanted to address both, then fine, give it the adequate capacity to address both private sector and public sector breaches. But if you don't want it to do with public sector, I think it should come out and say it, because there's no point trying to say, no, we are very concerned about it. We want this authority to do it. And then, leave it in this vague, hazy phase where you're not sure if it should be. So that clarity is very important. That would be the second thing. The third thing that I would say, which is absolutely necessary, is the list of 14 functions that the DPA is supposed to do, right? Which is listed out currently, and along with the function on non-personal data, there has to be some level of prioritization. This may not necessarily be possible within the Act itself. This is something that the government may have to come out and say in public and sort of say, we want the DPA to focus on these 4 or 5 things on day one. And by day one, I mean 2 years from now, not like the moment the law is passed. It's not realistic. It's not possible. You need those 2 years to set up the authority, staff it with enough people, give them let them start on the process of drafting their regulations, drafting norms, standards, codes, and so on. That is something that has to be, government should sort of say, these are the 5 things we want a DPA to do, right? They should focus on this. Maybe your focus might be to take complaints from people, to catch hold of data breaches, to set up, basic norms which companies which have to follow when they're transferring data, whatever it is. What do you think is the most important problem that the DPA is supposed to solve? That is something that the government should sort of lay out for them to say, please focus on these things. 2 other suggestions, again, not something which can be addressed in the law itself. One is to set out very clearly who should be adjudicating officers. Now, this is a problem which has plagued other tribunals because this is a quasi-judicial function, and inevitably, I think only SEBI comes somewhat close to doing this effectively, but you need to have if I have to sort of give you need to have a youngish lawyer with a lot of deep experience in that area. It just can't be some retired judge or some lawyer who just pick an appoint and say, now you're the adjudicating authority. It has to be someone with that in-depth level of knowledge in this. And it might have to be hard-coded a little bit into the law itself. The final point is, this is something which, again, can't be fixed in the law. So the previous point could be mentioned in the law. This one can't necessarily be mentioned in the law. But I would say this is a suggestion for consideration, which is, this is a new entity, which, as Renuka just pointed out, it should not be functioning like any other regulator in the country. It should be set up with a little bit of an entrepreneurial zeal or somebody who has a little bit of an entrepreneurial mindset. Nikhil gave me a great example the other day, actually, when he was talking about the Philippines Data Protection Authority, like how it was set up, right? That person basically said, I'm not going to wait for them to give me a building and an office and a car and a staff. I'm going to start in a coffee shop if I have to, and which is what they actually did. You need somebody who will have that entrepreneurial ability. It just can't be someone looking for a nice post-retirement sinecure, or it just can't be someone who ticks enough boxes in terms of, have the quote-unquote qualifications. It has to be someone with a certain level of entrepreneurial ability. And meaning to say that you have to learn to be quick, you have to learn to move quickly, and and also take up a little bit of take up challenges, which sort of Nikhil was mentioning, which sets the tone for the regulator. If you're just going to be another regulator who will sit in a nice, comfy office somewhere in Delhi and send out letters and send out circulars and send out notifications and run around trying to figure out how to enforce and all that, we're going to have the same conversation 5 years from now, maybe in another MediaNama event, going, oh no, we got such a nice law, why is it not being implemented? So this is the 5 sort of main points that I want to make.
Great. So Renuka, your thoughts, please.
Sure. So for me, I think the most important thing is codifying a lot of the processes of the regulator within the law, because we don't have the invisible infrastructure of an Administrative Procedures Act, for example, in India. So what would those be? I think we need to codify ex ante mechanisms, such as how will the regulator make regulations? What is the process through which the regulator puts out its regulation? What is the cost benefit analysis that the regulator will do? What is the kind of comment seeking that the regulator will do? So most regulators in India do put out their regulations. People comment and nobody knows what happens to those comments. They go into a black hole, and the final regulation that we see is exactly what was there before, or with some minor changes. So how is the regulator addressing the comments of the people who actually take the trouble? And whether the decision of the regulator, for example, to regulate something in the first place, to ban something, is proportionate to the problem at hand. Is it the least cost way of resolving the problem? Is the problem statement being identified correctly or not? So I think these things, I would say that they, so this becomes an obligation for the regulator in terms of regulation making. Similarly, I would have processes in the enforcement capacity, or in the way the regulator does enforcement. So how are notices sent? How are hearings conducted? How does the adjudicating officer talk to the investigating officer? So, I mean, Alok mentioned SEBI, but we know from some studies that we have done that there isn't much separation of powers in reality in the way investigations are conducted. Now, this goes against the basic premise of of natural justice, or of good administrative law. So I would think that codifying how each of these entities behaves within the regulator is extremely important in terms of audit. The third thing is on the issue of
Hi, sorry, I think, can we hear Renuka? I can't hear.
Can't really hear Renuka.
Yeah.
Renuka, we can't hear you.
Your IR over the place.
Renuka, we seem to have lost you. Could you log in again? Could you log off and log in again? In the meantime, yes. So in the meantime, Nikhil, could I ask you to just share your thoughts on this?
Thanks, Shekhar. So for me, I think let's start with what's not to be done, and therefore define what's to be done. I think the way this entire bill came together has lacked transparency. It's lacked due process. Like Alok also, like Renuka also mentioned, that what happened to the comments that all of us submitted. So I like how the TRAI functions with the openness, whether the consultation paper, all the comments are public, where there's transparency in how, although we don't know how it takes its decision and what the deliberations are, but I think at least that's a good start to have. Secondly, I would say that by design, the hiring at the top needs to be right. So maybe who we choose as a chairperson is important. Maybe a retired judge of the Supreme Court might be a choice. I'm not sure. Maybe Alok and Renuka would know better about this. I do think that number 3, the government should be governed by the DPA and have absolutely no say in the functioning of the DPA once the appointments are made. So whether it's a policy direction or it's a directive, the DPA should ideally be independent, but in order to, it needs to have transparency and accountability by design, so that it's not like the Reserve Bank of India, which seems to be a black hole when it comes to how it comes up with its decisions. And quite often, there's no proper consultation, and it just takes a call and just runs with it, which is why we need a payments regulatory board separately, and we need the RBI to get out of the way when it comes to payments. I do think that the DPA also needs more capacity, and to that end, we should have perhaps state level DPAs in order to for the DPA to be able to function, and maybe initial user complaints can be taken up by state level entities. We also need to, most importantly, separate the privacy goals of the DPA with the data economy goals of the DPA, and perhaps junk the data economy goals altogether, because this is essentially meant to enforce the fundamental right to privacy. So drop NPD, drop the economy goals, and just focus on enforcement of privacy to guarantee users their rights. I think there needs to be budgetary independence, where the DPA needs to have a guaranteed setup budget so that it can staff well, so that it can create various committees and staff those committees well. And there should be a guaranteed annual budget, which can be reviewed and increased periodically, but not reduced, so that the DPA has enough resources to do its work. Obviously, there will have to be iterations regarding how those resources are there, but budget is another lever that the government might have to exert control over the functioning of the DPA. And I think it's important for there to be, the appointment of a technical committee of advisors separately, because a lot of this role is going to be technical in nature. And I don't think, just going even by the way this law is worded, I'm not sure whether those who've written this law have necessarily understood the technology.
Yeah, so we'll now move on to another interesting aspect. So I will request Alok to just throw some light on the possible clash between different regulators, because now data has become a horizontal. Yeah. So the same data, there is a place where the telecom regulator, DOT can act, the health regulator can act, the banking regulator can act, and then you have this umbrella authority. Now, how will these function? The sectoral regulator vis-a-vis the central regulator, and if we have the state regulators on the same subject, harmonization of all this.
So I'd say this is something which it may be hard to predetermine in the law, for the simple reason that it's okay. It is described both in the data protection and also what you said, Chandrasekhar, as a horizontal. It's a horizontal regulator, right? Now, if we take, for instance, the Competition Commission of India, the Supreme Court of India in, I think, 2017 or 18 passed this judgment, which sort of said when it comes to telecom issues, TRAI being the sectoral regulator, gets the so-called first bite of the cherry, right? In the sense that they have to make their regulations, you have to comply with their regulations, and they will be the ones who will be responsible for even the competition aspects of the telecom sector. Only if you complied, or people are trying to comply with TRAI regulations, and it is found that even then there is a serious lack of competition in the sector, only then can the Competition Commission step in. Now, we don't know the exact contours of how that will happen, when that will happen. This was a little bit of a one-off case where they had to sort of separate the two regulators from fighting. What happens if the competition regulator and the data protection regulator pick a fight with each other? All right. Now, and the reason why I say this is because we have described both as horizontal. Now, that may not be very accurate, because the Data Protection Authority is it's horizontal to the effect that it deals with data protection across the board. But data protection is also something that fundamentally has competition aspects as well, right? In my view, I think, and this is also something that we are seeing develop in the United States as well, in Europe as well, more and more people are realizing that data itself, like collecting, aggregating large amounts of data, being able to analyze them and sort of process them from users, from whoever, gives you a kind of competitive advantage which is practically unbreachable. Like the reason why Facebook and Google have gotten to where there is not just because of acquisitions. Those are one element to it. but also because they are sitting on such vast mountains of data about users that they will always have an advantage over some startup. So this is a competition issue. Now, the Data Protection Authority might say, okay, as long as you meet our requirements under the rules and regulations that we frame, we don't think it's a problem. But we should not rule out the possibility that the Competition Commission of India might say, hey, no, this is a bad state of affairs for the economy in general, right? Sure, your particular regulations might protect user privacy in a certain sense, in a certain extent, but that is not the only or the major concern that a regulator has to be worried about. Similarly, we could find conflicts with other regulators, and here is where the issue can get complicated. If the Supreme Court's first bite of the cherry Prince doctrine, as I like to call it, is to be extended, then the Data Protection Authority will have to take a backseat to pretty much every other regulator, except maybe the Competition Commission of India. So when it comes to RBI, when it comes to SEBI, when it comes to IRDAI, when it comes to even maybe the UIDAI in the context of Aadhaar data, or you could even say Election Commission, which has all of our data, the Election Commission may say, boss, we know what to do with our user data. You don't try to tell us how to do it. If there is a breach, we'll punish in accordance with our regulations and rules. And if the Supreme Court's doctrine is to be applied, then the Data Protection Authority has to step back, has to say, okay, you know best because this is the specialized field. You're the sectoral regulator in this area. I'm approaching it in a general way. So one, I would say conflict is pretty much inevitable. It is going to happen. Two, our current jurisprudence hasn't evolved to get a more nuanced way of approaching this. Three, we have to be comfortable with saying that in certain occasions, the concerns of privacy may not be the only way to look at a particular issue. That this cannot, as important, as necessary, as vital as this exercise is, this is something that needs to be accepted, that this is going to be one particular concern in a wide area of issues.
So yes, Renuka, I'll bring the same question to you. Thanks, Alok. This was a very interesting take. So Renuka, the question is that how will different regulators grapple with the same thing, which is data, which has now become a sort of a horizontal, with several regulators looking at the same piece of data. So I was giving the example of a health record, which will possibly pass through telecom networks, then to the hospitals, and then there'll be various regulators who will come along. So how will this be harmonized?
I think I kind of agree with what Alok has said, that this is an incredibly difficult issue and we need to get into arrangements between regulators on who does what and who looks at what. So what is the jurisdiction of one regulator over something versus another, and which regulator has precedence? So for example, when it comes to questions on banking, does RBI have precedence over DPA, or to the, or maybe the DPA then does not frame rules on some of the data storage issues on banking because the RBI has already taken a lead. And this kind of segues into the point that Alok was making earlier, that instead of the 14 functions, if you want to start small, then you may want to start with those areas where there is an absolute vacuum. So if you look at the financial sector today, there isn't an absolute vacuum. You already have sectoral regulators that are doing certain things with the data. And if the DPA has to evolve, then perhaps the place to start is that sector where there is no regulation to speak of, or where data is actually flowing in a vacuum. And then as the DPA also evolves, it sets up coordination mechanisms with other regulators. And I also want to emphasize the point that Alok made, that at certain points, maybe there are other considerations that become more important than privacy. And this is just something that it will evolve. I don't think that we can find answers to this on day one. And if you may allow me, I want to respond to something on capacity building that was being said, but I got dropped off.
Sure, please.
That Nikhil was mentioning. And I think it ties in also with this interregulatory coordination mechanism, which is that a lot of what we are expecting the DPA to do is apply its mind. So, for example, there is a right to be forgotten right in the bill, right? It is non-trivial to figure out when is it that it should be accepted and when is it that it should not be accepted, or when is it that the request should be denied. I don't think that many of these things can be codified. At best, you can codify the principle around which how you will process some of these things, or how the DPA will process the requests for, let's say, taking down some information, how it will apply principles of proportionality when making its decision. And I think that, this is the kind of capacity building that we need to do within the DPA on how best can it apply certain ways of thinking about proportionality, or how best it can quantify harms coming from a data breach, for example, or coming from a particular action, for example, such that the action that the DPA takes is just and proportionate and also expected. It's not a surprise that when something like this happens, you will think that the DPA will behave in a rational manner, for example. And perhaps when this kind of training is done, it also helps in the interregulatory coordination mechanism. So yes, I agree that we need to do capacity building, but the capacity building also has to be about how to apply some of these principles in the way the DPA makes its regulations and also does its enforcement.
Thank you for that, Renuka. I will now segue into the fact that there are dozens of regulators in India and regulating a very plethora of different subjects, etc. So do we really need to reinvent the wheel and start from scratch? And in your view, what would be the regulator which would be the closest, as far as even the framework is concerned, to a data protection authority, so that we have at least, say, a 25% framework in place on which we build it and modify? Or you feel that there is absolutely nothing, it is easier to build something from scratch? Question to you, Renuka.
All right, so I think that in terms of codification of regulatory processes in the law, I don't think any regulator in India comes close. So we have never had this before, where we put on these obligations on the regulator to behave in a certain manner. And so for us, it's going to be new. Neither do we have the invisible infrastructure of something like the Administrative Procedures Act. So I would say that you could have the same structure in terms of, what division sits where, but in terms of manpower or woman power, for example, the personnel that will be hired into the regulator, the process of hiring, and in terms of codification of these processes, in terms of regulation making or enforcement, as I've said earlier, I don't think that we have much precedence in India, and therefore my view is that on that we have to start afresh.
Alok, as a constitutional specialist, I would take the analogy of the Indian Constitution. We borrowed many features from constitutions across the world. So there are similarly many regulatory models like the Information Commission, Consumer Protection Act, Competition Commission. So what are the different aspects and best practices? Like, for example, Nikhil alluded to the very robust consultation process that TRAI has. What are the best practices we can borrow from different existing regulators?
That list is very small because I don't think we can say that we have one particular regulator which does one thing absolutely well. I suppose, just to take on from what Nikhil mentioned, say one thing like TRAI does a good job of public consultation before it puts out the, the regulations out there, right? Because it takes on feedback or response to feedback where needed. I think that's a good practice which can be followed. Beyond that, the difficulty is this is also a beast which is being asked to do many different things. So the question for me which comes is, does it make sense to borrow something hypothetically from like the Consumer Protection Act? Because that is explicitly constructed as a tribunal. It functions only as a tribunal. It functions only for the simple purposes of hearing cases. Here's party X, party Y passes an order. Now, in the context of the DPA, sometimes it hears party X and party Y. Sometimes it might have to do with what the DPA itself has said we should do. Here is where it gets tricky, because the Competition Commission of India, unfortunately, has made a complete dog's breakfast of this whole thing. Most of the Competition Commission's orders end up in court. They get stayed. They're not able to justify it. The whole thing goes back. And it's a procedure, and Renuka made this point earlier. It's a procedure which they seem to be making up on the fly, and no one seems to know how. Are they like a judicial body, a quasi-judicial body, purely administrative body, purely enforcement body? There's complete confusion. And I would say perhaps maybe we have a list of what not to do rather than a list of what should be done, right? So I think from that perspective, I suppose this is a body which is going to have all three functions. It is going to have a lawmaking function, which is in the context of regulations. So there you want that process to be as transparent as possible. You want them to put out drafts. You want them to respond to drafts. You want them to come out with concept papers which show what they're thinking, what they're aiming to do with this, have wide consultations, and then come out with the regulations. They're going to have an executive function as well. And that executive function cannot just be a retired policeman waving a danda around saying, do this, do this, do this. It has to be someone who is well equipped in that field. And this is where you need to have maybe someone with expertise, with specific expertise in cybersecurity, in data protection, in data sciences, and so on, who is part of this. Finally, there is a judicial function, right? Before we get into the administrative law categories of judicial or quasi-judicial, I'm defining it very narrowly to say where you have to hear parties and pass an order, which applies only to that party. There should be a very clear set of regulations on how the proceedings will continue. And it should not be for the chairperson to sit and hear the cases or anything like that. They should be in the largest superintendents of this body. The adjudicating officer should have a very clear, see, this is the importance of a legally trained person, because they will be able to see a set of rules and regulations and say, this is how I am supposed to conduct my proceedings. And given that the hearings before the Data Protection Authority will have massive civil consequences, imagine that you are actually trying to create a civil procedure code for this. You don't have to go into the detail of 150 sections and 50 odd orders, but you need to have something which essentially is a manual, which you will be bound by, which you will follow as a adjudicating officer under this. And nobody's in any doubt how should hearings proceed. Renuka made this point about, what will be the relationship between the investigative arm and the adjudication arm. They should clarify it, that they will be in the position of a party insofar as the hearing is concerned. They don't get to obviously appoint the adjudicating officer, but they will be subject to the same rigors of evidence, of discovery, of placing material on record and so on. So in that context, I think having a very clear idea that this is going to be a body which will perform these three very broad functions. You said draw an analogy from the Constitution. We can sort of say that to that extent, there is a legislative, there is an enforcement / executive, and there is a judicial function. Keep these three separate. By separate, I don't mean totally watertight compartment. That's unlike, say, even the Constitution doesn't make it so separate as to make it watertight, but have this kind of functional and procedural separation.
Yeah, that's really, really
Can
good.
I add
And
to that?
sure.
Sorry, can I add to that? One thing that I want to add to is that we do also need some way of a judicial review mechanism, because very often
We are losing you, Renuka, and in the interest of time, I think I'll hand over to Nikhil. There are a lot of interesting questions, and Nikhil is best placed to put people on a spot with questions. So over to you, Nikhil.
Sorry, I was on mute. Thanks, Shekhar. Alok, question for you. How will sharing of data between two government agencies and departments work? And what role can a DPA play over there?
This will need a little bit more specific detail. For instance, just to take an example, the Election Commission, for instance, can't just share Election Commission because it is bound by its own rules on what kind of data it can share, what it can't.
Let's say what is happening during Aadhaar.
Sorry, what?
Let's say what was happening with Aadhaar, where department
pre-legislation or post-legislation. So because the question is, so see, because that's a tricky point. And the reason is because some of these are already
Let me rephrase this then. Let's say one of the requirements under NatGrid is for many public and private databases to be connected together.
Yeah.
Now that's effectively the MHA is collecting data from multiple government departments on a real-time basis. That's the plan. So how will what role does the DPA play in either disabling or enabling that kind of data sharing?
I don't think DPA will play much of a role in that, for the simple reason, because there you're adding another element which DPA currently does not have in the way it makes its regulations or carries out its enforcement, which is the questions of internal/national security and law and order. Now, DPA is again, not say that it can never do it. If it has to, it will have a very different composition. It will have very different people on board. It will have a very different way of thinking. And the problem and the danger is, if you create a body which is supposed to be on trying to balance concerns of privacy and national security, all the time you see the Supreme Court coming down on the side of national security. No DPA we're going to design is ever going to come down in the side of privacy. It'll start thinking of everything from the perspective of national security. That's a danger that we create. There is a way to account for this. It may just not be this is the authority which has to address this issue. Because the danger is that even where it has to perform its function for protecting the rights of individuals vis-a-vis large companies and so on, if it is sort of seeing those also from national security, economic security issues, we have gone wrong with the design of the DPA. So therefore, I would say again, with government functions, let us make this distinction. It's important to make this distinction, because if you sort of create a body which looks at that and say the regular day-to-day functioning of the government and also this thing, you are getting, it's going to be completely lost. It will only do the basic minimum, which is to sort of keep the government happy on national security issues and forget about the rest. So there is a very serious danger.
Can you give me an example of where the DPA can actually step in, where it's not a national security issue?
So I would say there's something like, for instance, let's say social welfare department in most states collects data of beneficiaries of various schemes, right? SC, ST students, so for scholarship schemes. For instance, SC, ST students who apply for scholarships, they collect their data. They say, here we are collecting the data. We have details of all these students. We have given so-and-so scholarships and so on. There is a transparency function where people need to know how much money has been given to the students and whether it is lawfully being done. But perhaps because some of these students may be minors, you shouldn't be revealing their names, their schools, their addresses, their phone numbers, etc., etc., etc. Right? So in that context, when such a leak happens from the government, that is something that DPA should be able to say, boss, what's wrong with you? Why are you putting out all this information in the public? People only need to know, right? And if they are major students, that X number of people have received the scholarship from the state government, so that it's verifiable and you know it's correct. But if you're putting out sensitive personal information, like as to where they live and their phone numbers and so on, see, this is a tricky thing. This gets complicated if you say something like Manrega. Something like Manrega, there is actually a mandate to put out the particulars of the people who have obtained the benefits under the social welfare scheme. And that is an important part of transparency, because people need to know who are the people who got benefit from this. Who are the people who sort of got, who are the people who have actually worked in the scheme and have gotten the money and so on and so forth. If you go to some rural parts of North India, you'll actually find a list of Narega beneficiaries painted on the walls of the panchayat buildings. Nobody has a problem with that, because people see that as a huge and important transparency function. Because people know, if my name is on it, tomorrow I can go and say, hey, my name is here on it. Why are you not giving me work? But they also know that if somebody's name is on it who has not gotten the benefit, they will hold the government to account. So I gave you some somewhat simplified example, in the context of the social welfare department, having the details of SC, ST students in the context of scholarships. But that can be complicated, because there will be concerns, especially from the government. There will be concerns of how do we balance the needs of transparency to make a lot of information public, but also to ensure that the beneficiaries aren't harmed in this process. So I think there is a set of governmental functions where the DPA can definitely perform a very important function of making them aware to say, this is sensitive personal data. You should not be putting this out. This is how you can meet your requirement of transparency without compromising this. And I think that is an important function that the DPA can do.
Thanks, Alok. Renuka, what kind, if you're here, what's the level of expertise in India that we would need in the DPA for it to work effectively, especially if it turns out to be just another government department by the shape of it so far?
So, can you hear me now?
Yes.
Okay. It looks like, the DPA is a very complicated body. It has a very complicated set of functions. So I think that we need all kinds of expertise, right? So not only do we need the expertise on technology to understand what's going on, but we also need expertise in terms of the law and in terms of ethics, for example. So, coming back to the example that I was talking about, in terms of right to be forgotten. When you are applying something like a principle of proportionality, or when you are thinking about quantifying harm, because that will be the basis of the next step that you will take, it is non-trivial to quantify some of these things. And therefore you need people who are able to see more holistically and think about the various trade-offs between the decisions that the DPA might have to make. So I think that from a subject matter perspective, you need all of these things. And then a lot of the people that we hire at the regulatory staff level are not given enough training to on processes. And I suppose that what we need is also training academies or institutions that can design syllabus that can be imparted to regulatory authorities. So, for example, if you look at cost benefit analysis, which is one of the pillars of doing better regulation, there isn't anybody in India who is actually offering too many courses on how to do CBA, because a lot of CBA is speculative. You don't know ex ante what the costs will be and what the benefits will be. And so this requires tremendous skill and training. And I think it's important that we start building this capability in the country so that not just the DPA, but the overall regulatory ecosystem can do a better cost benefit analysis and better regulation making.
Maybe both of you can address this one. There's a great question from Sundar about wanting a perspective on vesting the governance of both personal and non-personal data in the same authority, and how should that work as opposed to demarcating the regulators?
Can I go first?
Yep.
I know a lot of people have had issues with this. And I was on a previous MediaNama event about non-personal data. We did have this discussion that we were not clear what was the point of regulation on non-personal data. I can see like some vestige of this non-personal data regulation having some impact on personal data, perhaps, and maybe there might be some basis for it. I would see the non-personal data discourse as an extension on the personal data discourse, where you see that something to do with personal data is in fact something which needs to be solved at the non-personal data level, or it might be that the data that you're collecting, which is not per se personal data as defined under this act, is having some implication on it, and therefore it might be the data protection authority. I mean, the bill is not, or rather the committee report is not very clear on this, and as far as what regulatory pathway would be most efficient, put it on the back burner. I would say it is not something that it should be an immediate priority for the DPA. And combining trials of different adjudicating, no, bad idea, because they come at it from very different perspectives. And it's not like you can arrive at some harmonized way of doing this. See, and again, this is only one particular aspect of the problem, Sundar, that this addresses, which is the adjudicating aspect. Now, the Airtel case that I sort of mentioned had to do with an adjudicatory aspect, not so much a legal aspect of it. What I sort of said about the sectoral regulators prevailing over the horizontal regulators might have to do with the lawmaking function, right? In the context of say a specific adjudication, I think the Supreme Court has said very clearly that they will decide on jurisdictional issues, will get so-called the first bite of cherry, but CCI is not completely ruled out. The CCI's role is not completely ruled out. I think somebody had raised this question in the chat. Just to clarify, in the context of adjudicatory function, yes, the first bite of the cherry is for the sectoral and then the larger horizontal. but there is going to be also conflict in terms of the regulations and norms that the regulators create on this. And that is something where jurisprudence hasn't evolved. But if the same principles apply, you will find that the sectoral regulations might end up prevailing over the larger horizontal ones.
Renuka?
Hello, sorry.
Yeah. So it's essentially about how do you think the DPA should deal with both
Oh, sorry. On the my views on the NPD are that I think that the way we have framed the regulation of non-personal data requires a complete rethink, and I don't think that the NPD, at least at this point in time, should be part of the DPA at all. We really need to think from first principles on how to regulate non-personal data, if at all. And in the comments to the NPD report, we had put out our suggestions on how we think of NPD. So I don't want to bring them here, but my short answer would be no, I don't think that right now is the time to do non-personal data, certainly in the way that the committee envisaged non-personal data.
There's a question from Bilal. So he said, do you think there's an essential difference in the nature of the DPA that sets it apart from other regulators? For example, one of the clauses that has been criticized is clause 86, which after the JPC report allows the government to issue direction to the DPA even on matters that don't pertain to policy. However, there are several similar provisions in other acts such as the Competition Act, SEBI Act, IRDAI, etc. However, given the need for cross-border acceptance of the DPA, could it be differentiated from the others?
So I'm not sure exactly what the question is. My sense is that the DPA is modeled along the current or existing regulators. And in terms of differentiation, I think we need to differentiate it on the processes that govern the DPA, not so much as, you need to begin there. So I'm not sure I've answered that question.
Okay. I mean, my take on that is that anything that ensures that the DPA isn't an extended government department, which the current design seems to portend, would be useful.
Just to add to one point on the specific issue of power to issue directions. This is a provision which is there in multiple laws. I think Bilal has pointed out rightly, not just in the context of financial sector regulators, also in the context of power regulators. There is also a fairly well-developed set of case law which says how this power can be used and how it can't be used. So to give one example, Delhi government can't tell the Delhi Electricity Regulatory Commission, you fix price at Y. That is the function of the commission. So commission can't be directed in that way. It can't be a direction to say, do this only in this particular way. It can only be on questions of policy and so on. So in a sense, Delhi government can say, please fix your prices in a way that furthers people's access to electricity, right? At that level, it can't say fix your price at 1.2 rupees per unit and so on. Just to give you an example, there are a bunch of cases which have addressed this. But also, I agree with what Renuka sort of says. I don't see there is something essentially different. It is that we shouldn't kind of assume that just because certain regulators have functioned in a particular way in India, we also want the DPA to necessarily function there. There is an opportunity for us to build, I think, something like a well-functioning regulator. Nikhil is probably a little bit pessimistic about this, but I'm a little bit more optimistic about this, to say maybe we won't succeed on day one, maybe we may not succeed on day 100 also. But I think this is something where it's possible perhaps that at least here might be in say 5 to 10 years from now, a well-functioning regulator which say about 90% of the time does what it sets out to do. That's well, I'll end it there.
Alok, Deepak Maheshwari has a question for you. He asked about while the number of functions are responsibilities proposed, while the number of functions that are responsibilities proposed for the DPA might be a challenge by itself, do you see any potential conflicts across the different functions of the DPA?
Sorry, do you mean inter se? intersay these functions conflict?
Between the functions.
I don't think so at the moment. At least for now, at the level of generality in which these functions have been defined, I per se don't see it. It could happen maybe 5-10 years from now, once they start framing regulations, once they start framing once they start responding to specific needs of people who complain and so on, we may see certain but I per se don't, because it's still drafted at a very high level of generality, these functions. So it will not be possible to say this will definitely conflict with this. We may need to wait for about 5-10 years before we have full clarity on this.
Shrija has a question about whether is there any way to focus on the individual and not allow a corporatized or a business influence within the regulation of the DPA, especially since we're referring to having law firm lawyers who may be experts in data protection issues.
Good question. And I think, Shrija, what you're talking about is what is called regulatory capture. This is a very real problem. It is something that regulators around the world grapple with. It is something that they are concerned with, and it is something which is possible. Now, here is also the paradox, right? In a sense, you are not going, there is no magical field of people with experience having worked on issues of data science who are not in some way today involved with the profit-making part of this. There may be a few people, but that pool is really, really tiny. You may not be able to find someone who will be willing to be on this DPA with the necessary qualifications and the necessary abilities to run the DPA as a member, as even a legal member on the panel. But it might be possible to sort of eliminate, say, those with some very obvious conflicts of interest, like somebody who's like been the face of some obvious major litigation, who has only appeared for or rather who have been part of transactions and so on only for like large companies and so on and so forth. It may be that, but I'd say this is a problem which will have to be resolved on an ongoing basis. I don't know if there is a large pool of people with the legal expertise on data protection from whom you can draw to staff the DPA on day one. I'm not saying like forever this is going to be a problem. It might be a problem on day one. It might be something where you may have to sort of compromise on one of these two values. You may have to say this person has excellent expertise, but they're so closely associated with a particular set of companies involved in this that we can't risk the DPA's credibility being affected. Or you may say we have somebody with not as much expertise, but they have absolutely no relation governmentally or to companies, and therefore we would rather have this person. It's a choice which is going to have to be made. You're never going to find that perfect unicorn of someone with absolute ability and complete lack of conflict of interest on day one. But this is a problem which is going to have to be grappled with at some point of time.
I want to take this a little further and say that this is not just a problem on day one. I think that this is an issue that will keep coming up because the sector evolves, and generally the private sector builds expertise faster than the government sector. And I don't think that revolving doors is a bad thing. So just because somebody has had experience in the private sector and is now coming in government, I think in fact that's a great thing, because then it exposes the people in government to what being in the private sector is like, to what issues are like. And there may be other ways of ensuring that there isn't regulatory capture. But to say that we don't want anybody in the private sector to come into government at all is something that I would not agree with. In fact, I would encourage that the more revolving door we have, the better it is, because perhaps government will be able to see business more rationally than it does now. Because today there is such a separation that a lot of the decisions that the government makes, they do not understand the cost that it imposes on businesses. So I would say that we need to think about revolving door far more carefully and not dismiss it as regulatory capture all the time.
Just on that note, for both of you, starting with you, Renuka, what should be the priorities of the DPA on day one?
So I think, set up the organization right, set up the processes of rule making and of enforcement right, because these will carry you through over the next 10 years. And these will also build credibility for you as you go along. So that would be my number 2. And perhaps find ways to hire people through a non-traditional route than government, so that you can bring in more capacity from outside the government into the DPA. And if your processes are right, then problems of regulatory capture should not arise. And sorry, the fourth one is start with a limited goal. I completely agree with Alok when he said earlier that starting with everything is not going to happen. And so think carefully about what is it that you want to begin with.
Alok, anything to add?
I've said this and I'll just reiterate it. That entrepreneurial spirit needs to be infused into the DPA as a young institution. I think we sort of tend to confuse this entrepreneurial spirit only with money making. I don't necessarily think so. Having seen the development sector, think tanks policy and so on, I see how important having that spirit is. And that spirit is like, sort of that can do, make do kind of attitude where you want to go out and achieve things and make sure that your organization shines well and you build something from the ground up. I think that is really what we should have. We should not like this with all the resources and the best people. This body will fail if at the top there is a culture of we will wait and see what happens. We will wait and see what happens. We'll wait for government to do this for us. We'll wait for individuals to come and complain to us. We'll wait for private sector to drive the innovation and the regulation forward. And we'll just keep responding as and when. I think that will be very destructive for this. Obviously, they don't have to worry about fundraising or anything like that, luckily. But in terms of developing that entrepreneurial spirit, I think, yes, definitely you can involve outside experts from at the level of enforcement officers and so on. But I think this needs to come a little bit from the chairperson and the members. You need to have a slightly go-getting, make-do kind of bunch who, and I know the government is not necessarily known for that, but there is talent within the government which is capable of doing this. There is talent in the private sector which is capable of doing this. It's just a way of finding the right people and putting them there. But if I have to optimize for anything, I would optimize for this. Can we find a bunch of people who will go out there and who will be like, I have been given the responsibility to build an institution and my name will be associated for the rest of my life. Can I do this now?
Well, as long as it's not the move fast and break things onto let me finish. I hope it isn't the move fast and break things entrepreneurial approach that the UIDAI adopted.
Yes, exactly. Yes, of course not. But in a different perspective, but from a different sense, but yes.
One last question before I hand over to Manish. Should the DPA be appointing adjudicating officers or should the latter be appointed via a distinct process to ensure better separation between the DPA and the adjudicating officers?
I don't have a particular view on this for the reason that there is an appellate tribunal above the adjudicating officer. There is an appeal to the Supreme Court afterwards. I would say at the level that we are looking at, I would say the adjudicating officer, you'd want to optimize for competence more than how quote unquote independent they are from the rest of the DPA. I'd say if the DPA can find competent people with legal training to be adjudicating officers, go for it. Because any failures in terms of taking too much of the view of the DPA and so on, you have an appellate tribunal which is not appointed by the DPA. You have an appellate tribunal and you have the Supreme Court in appeal which can address this. But I think more than you don't need that kind of trial court judge level of independence in something like this. You need competence first. You need somebody who understands what the issues are, who can really apply their mind in a legal manner and take a decision. Because it's not like these are cases being decided in some corner of the world. There'll be hearings, there will be opportunity to present evidence and so on and so forth. And as long as somebody who's familiar with how to hear cases in a particular procedure, follow basic principles of natural justice, it's fine. I'm not particularly concerned who appoints the DPA. Prime concern should be, do we appoint a bunch of competent people who can take decisions in a reasonable legal manner is the real concern.
So I have a slight difference with Alok here. I think that, while having an appellate mechanism or a Supreme Court, it's great that it is there, but very often the regulator is so powerful that on many instances, the regulated entities are so scared that they will not go to the appellate body or the Supreme Court. Secondly, even if they do, the time that it takes and the damage that bad behavior by the regulator can cause to the individual or to the business while the proceedings go on and while you take it to the appellate court, 10 years can go by. As we have seen in many cases, I speak of SEBI because we have a paper where we read orders of SEBI to see how it performs. And the cost of that time is not something that is trivial. It can be very expensive when we drag people through these lengthy proceedings. So I think that I would be far more worried about separation of powers within the DPA and how the adjudicating officers are appointed and who it is that they report to and what kind of conversations are allowed between the investigative arm and the adjudicatory arm. So it's great to have an appellate tribunal, but that is not enough.
I think we could go on. Thank you so much, Alok and Renuka, for sharing your thoughts. I'll just end by saying that I hope, and something that we started with, that the DPA doesn't become an extended government department and retain some semblance of independence. And I hope whatever amendments are made before the tabling of the bill ensure that. Otherwise, we're just going to have more and more litigation coming our way. Thank you so much for joining us. I'll hand over to Manish for the next session, which is on something that should matter to all of us. Our rights. What rights do we have as users, and how are we likely to enforce them? And where is it that we are restricted from enforcing our rights? Manish, thanks.
Am I audible?
Yep.
Okay, thanks, Nikhil. Welcome to all our panelists and to our audience, those who've joined us, as well as those continuing from the previous session. 2 years ago, almost to the day, a number of us convened at the Royal Orchid in Bangalore at another MediaNama event to discuss the then draft Personal Data Protection Bill, which had just been sent to the committee, to the Joint Parliamentary Committee. 2 years on, the world has transformed, but has the bill done so? That's what this session will hopefully try and unpack, with particular focus to the end user, that is shown of all legalese and technicalities, you, me, or the average citizen whose data is being processed. I have an excellent panel of lawyers with me to discuss this, and I will come to each of them in turn. Before I start, I just want to lay out the session a bit. We'll do this as a freewheeling conversation where I will come to each of the panelists with a question or two. And after 2 or 3 rounds of this, we should have some time for questions at the end. I request the audience to type your questions into the Q&A box. If your question is directed to a specific panelist, please mention their name. And I'd encourage panelists to type out answers in the Q&A box as well. I'll try and bring them into our conversation where possible. And at the end, if we have time, we'll do some live questions where the audience can ask questions on video directly to the panelists. So without much further ado, let me get into the meat of things. First panelist is Lalit Panda, who is Senior Resident Fellow with the Public Law team at the Vidhi Center for Legal Policy. Lalit is also part of Vidhi's Charka initiative, which is doing some great work on constitutional law and practice in India. So Lalit, let me open by asking you, in relation to user rights, when we look at this data protection bill, and in particular the new version, what exactly are these rights that we're talking about, and how do they interface with the broader omnibus right to privacy that the Supreme Court laid down a few years back?
Right. Thanks so much, Manish, and thank you so much to Nikhil MediaNama for inviting me here. The subject matter of discussion, that is to see how this particular legislation, the data protection bill, or what was previously called the personal data protection bill, how it protects certain kinds of individual rights This can become slightly confusing if we don't set out the terms a little bit about which kinds of rights are involved and which are the ones that we want to talk about at particular points of time. People who have cursorily read the bill will notice that there is a chapter of the bill that is called Rights of the Data Principle. And so it'll be easy for somebody who doesn't have who may not be thinking of it in those terms, to think that the only rights of the data principle that exist, that is the only rights the user that exist, are the rights that are mentioned in that chapter. This is a misunderstanding. That is a specific chapter in which a particular kind of rights are granted explicitly to this individual, to individuals like us, that what we're calling users right now. Essentially data principles, people to whom the data relates, or the person who's identified by that personal data. So that set of data is one thing that we can talk about. But as a whole, the data protection bill itself is, the entire architecture of the bill, at least until it was the personal data protection bill, was designed towards the protection of the right to privacy. And the right to privacy was a right which existed in the Constitution across a lot of period of time. It was confirmed with the 9-judge bench of the Puttaswamy, in the Puttaswamy judgment. There is a right to privacy, and it has many alternative forms. One of the forms being the right to informational privacy. Essentially, this right, the fundamental right, suggested that an individual should have some nature of control over the data that relates to them. Some nature of control should exist. And that nature of control that the Constitution requires is something that the data protection bill is supposed to implement. And now, to understand how a bill, a law that a legislature is passing, is supposed to relate to a constitutional right, it is important to just understand this one distinction between two kinds of ways in which fundamental rights are implemented. One is when the government does something, an active, positive action it takes, and that active, positive action is subject to judicial review because it violates constitutionality, because it violates the Constitution in some way. It can get struck down by a court, right? The other way is that the Constitution may require the government to do certain things, and a failure to do those things may be another way in which the government may be doing something that is unconstitutional. Now, it's important to note that the latter way of unconstitutional action is ordinarily considered to be much rarer. There are very few instances in which this is actually considered to be, it's considered possible that you can approach a court and say that the government has not legislated something, it has not passed a law, or it has not made a provision of a particular kind, and so my fundamental right is being violated. The explicit requirement under the Constitution for law related to untouchability, for example. The right to education is another instance where there's positive requirements to engage in some legislative action. So these are some recognized instances. In the Puttaswamy judgment, there was also clear indication that creating a law by which the government would protect individuals from privacy violations from other private individuals and from the government was also put in place. So it seems to be the case that there is some positive duty to legislate. One question that has to be there in fundamental right to privacy, how far the data protection bill is implementing it, is to see what level, what extent, what specificity, what details of a data protection law are mandatory requirements of the Constitution, and what extent of it is legislative policy. So far as fundamental rights are concerned, if a user feels that their fundamental right is being violated, what can they challenge this law on the grounds of? I think there are certain grounds where privacy, and I think even more significantly, the right to equality may be under challenge. That's the way probably one can challenge the data protection bill. So that's one set of rights. Another set of rights that are there is that across the bill, there are many duties that are imposed on data fiduciaries, the people who are processing or using the data. These people using the data, they are subject to certain duties. I'll give you one small example. One duty is the duty to notify that a data breach has taken place. I have your data, and that data has gotten breached. It's been released unauthorized in some way, some accident, some negligence has happened. Some other people now have that data. Now, in the instance that this takes place, I'm supposed to notify certain individuals. There is considerable discussion that this notification should be to the data principal, and that this requirement should be there as per the law. But right now, the bill just says that you should notify only to the data protection authority, and the authority will decide whether or not the data principals or the users will hear whether or not their data has been breached. Now, this also is a question of rights in a way. It's a right to what? Right to information in a way, right to transparency. Any instance of privacy where you have to gain some control of your information requires that you be informed in some manner about what's happening to your data. So many statutory obligations that are not explicitly mentioned as rights of users, they are also indicating rights that users are supposed to have. It is not possible for them to consider that they have a right to information or transparency unless that obligation is accurately, appropriately strong. And lastly, we have the rights that I mentioned right in the beginning, the rights mentioned in that chapter called rights of data principle. These include such things as the right to be able to confirm whether somebody has your data, the right to be able to access it, the right to be able to correct that data if it is wrong, the right to be able to have that data transferred from one fiduciary, one processing entity to another processing entity to have it transferred. It's called a right to portability. And finally, there is something called a right to be forgotten, which has variously, it relates to erasure of data, which does not need to be processed by that entity anymore, or it relates to stopping publication of that data if it is being published. So all of these, this set of rights, this is specifically explicitly named as a list of rights that is there. These rights have to be actioned by, and also the previous rights that are there, the second set, that is rights that arise from duties. These have to be, these are actually exercised by users by first placing some kind of a complaint or a complaint to a grievance redressal officer if it is a violation of a duty, and a request if it is one of the rights in the data principle chapter, rights of data principle chapter. And you have to place these requests to the fiduciary, which means your first port of call for any user, if they feel that the law has been violated, is to approach that data fiduciary, the entity that is using your data. That is what the law is currently prescribing, that you have to approach them with a request or an application of some nature. And if they fail, then you go to the data protection authorities adjudication system. That is what is there. The exception is the right to be forgotten, where there is a requirement that you can approach the adjudicating officer directly. So I think it's important that we separate these three kinds of rights. There's various distinctions about how we should discuss these rights, and I think it's important that we cover all as well. So hopefully we can take this from there. Yeah.
Absolutely. Thanks very much, Lalit, for that very concise and clear framing. I'm going to come to Vrinda now. Vrinda Bhandari is an advocate at the Supreme Court of India and has been very closely involved with privacy litigation at the court, including in the Puttaswamy judgment and afterwards. And I'm hoping she'll be able to bring some of that perspective to this discussion. Vrinda, when this report and this draft came out, you wrote an op-ed where you said the JPC report and this bill protect the government instead of personal data of citizens, right? So from you, what are the two big misses and maybe one or two big hits of this revised bill?
Yeah, thanks. Just before I answer that question, just one more, I wanted to add another kind of set of rights that Lalit had kind of indicated, which are also, when we talk about user rights, also thinking about like children's rights as a specific kind of bucket of user rights, and also user rights in terms of like employee rights, which has been dealt with in terms of an exception or an exemption, but is really also a certain rights that are then given to employees. And so that's just one factor, I wanted to kind of mention. And other rights, the examples of which he had mentioned in terms of data breach, so the right to have a data protection impact assessment done if it's a significant data fiduciary, etc. So that's just a brief of kind of, I wanted to add that. I think, yeah, so in respect of the op-ed that you had talked about, this comes from my general reading and understanding of the bill, that even if you see the progress of the bill, and I guess this also goes back to the point of what is user rights. It's not just access correction, but it's also a right against, for instance, surveillance, which is one of the things that I have been really concerned about for a lot of time. Now, the title and preamble of the bill, as we know, has always been the data protection, personal data protection, and now data protection law. Interestingly, the JPC made one very important change in the long title, where they said that the purpose of the bill, so the very objective of the bill, is to, quote, ensure the interest and security of the state. So the entire Puttaswamy litigation and the Justice Sri Krishna Committee report that came out of that came from this perspective of the individual is at the center and the heart of data protection, right? So the autonomy and the choice that an individual exercises. So even, we in fact had always had some objections that even when you're framing the PDP bill, why are you talking about digital economy in the same vein necessarily as individual rights? Because sometimes they are obviously competing. But now to elevate government interest and the fact that the objective of a data protection law is to ensure national security is something that's very concerning. And we see this reflected really in the manner in which two specific clauses I'd like to very briefly touch upon, and then we can go into it in later detail. One is the fact about the exemption clause to all government agencies. So unlike even the Justice Sri Krishna version, which at least tethered the fact that there are some exemptions to all government agencies, proportionate. So it used the Puttaswamy language. What we have seen in the JPC and in the PDP bill is the government, if it believes that it is necessary or expedient in legal parlance is simply convenience. So if it is expedient in the interest of national security, public order, which again like means a lot of things, they can exempt any agency, any government agency from the entire application of the act, right? And there is no requirement in the law written in for legality or proportionality or that this has to be authorized by law. The change the JPC made is twofold. They made it that this will override all other laws. I'm still not clear on how this would apply with the RTI Act. And so, what that interpretation and intersection will be, I think is something we need to see. What does it mean that this clause will override specifically every other law? And the second is that they have tried to say that, look, the procedure by which this exemption will be applied will be necessary, will be proportionate. But that proportionality procedure does not apply to the substance. So the government's reasoning that, yes, I need to exempt this government agency because according to me, it is in public order or in national interest to do so, means that nobody can really effectively challenge that. So that's one kind of exemption, and we can talk about what that means later. The second kind of exemptions, I think, are the fact that, which is clause 36, which actually is something that will apply to us as citizens a lot more, because that says that anybody can seek an exemption from effectively the entire law other than security safeguards if it is in the interest of investigation, protection, prevention of offenses, of any offense, which means like even a check bouncing case, or for the violation of any law in force. And this exemption, most importantly, can be taken even by our local RWA. It can be taken, when we install CCTVs, because the exemption is not, and that's very important, the exemption is not limited only to government agencies. Anybody can technically take advantage of that exemption, which means all this proliferation of CCTVs that we have been seeing, we've seen the role RWAs have played when it comes to, COVID and pandemics and the kind of restrictions they've imposed. You're essentially empowering them to say, no, this is important to prevent an offense, which essentially means anything. And hence we will then take away any rights, any consent, all of those things. So I think that is, for me, one of the biggest misses when we talk about government versus private agencies. The thing I would say, which is a big hit, and this is more, I think, from just the data protection perspective, is that I do believe, and a lot of people have said this before, so I'm not the first person to say this, is that we do need a data protection law enforced right now, right? Yes, there are going to be problems. Some of those problems hopefully will be ironed out when the law actually, before the law actually comes into force. Some of them will not be ironed out and will be challenged in court. That in itself should not prevent the law from coming into force. Because if you look at the constitutional structure today, individuals have no real statutory rights against any corporate entity. And so to give that right to individuals is absolutely essential. So I think like the one big plus, I think, is just the fact that there is a law. And I think we do need to speak about that. And yes, there are all of these problems. And I think some of them are very, very problematic. But I do think that does not mean we don't pass the law. I think it's really important to actually pass the law. So maybe for right now, I'll kind of just stick to this.
Yes, thanks, Vrinda. But on the note of what you said just before that, I'll come to Amber. Amber Sinha is the Executive Director of the Center for Internet and Society, Bangalore. CIS, as we all know, has been engaging deeply with the question of privacy long before the Puttaswamy judgment was even on the horizon. Amber, you also like Vrinda, you said that changes that have been brought about in the subsequent versions of the bill have given the government a veritable carte blanche, right? So I want to ask you specifically about the question of surveillance. While we have another panel after this that will deal with the government exceptions in more detail, could you briefly outline how surveillance has been addressed in the bill from a user perspective?
Thanks, Manish. And just to add to, I think, a theme that Lalit touched on very well right in the beginning, I think the nature of what we need to, let me start with saying that this data protection law or this bill, the entire legislative exercise comes from the reading in Puttaswamy 1, where privacy has been recognized as a positive right? So there is a positive obligation on the state to create a law which protects the privacy rights of citizens, not just from the state, but also from private actors. And I think in that light, we need, so I think in my view, there is a clear mandate that both the committee of experts led by Justice Sri Krishna as well as the JPC had, which drew directly from the interpretation of privacy in Puttaswamy 1. And I think the issues that we're seeing with regard to user rights are also where that mandate has not really been observed by either of those two groups, either in the first case by equating privacy with the need to boost data economy, or in the second case by equating it with the security of the state. So let me sort of start off by there. And I think what we have seen, as I mentioned, I think in the op-ed that you perhaps referenced, was that in subsequent versions of the bill, there has been increased powers of access to data which have been provided to the state, and also a decreased amount of oversight with regard to any state access and processing of data. And that relates to both surveillance related provisions that Brinda touched upon just now. And I think she mentioned the sort of inherent conflict between necessary and expedient. And let me sort of add to that by saying that if we look at the jurisprudence that Puttaswamy 1 relied upon, we looked at European jurisprudence on that, and then we specifically looked at jurisprudence which defined necessary as something that is not politically expedient. So actually to use both those terms together is quite laughable, to say the least. And so I think the point that Linda made about extending the protection of, extending the test of proportionality only to procedural matters, but not the substance of it, or the substantive reasoning behind surveillance actions being taken. But the other aspect of state access to data that I'll touch upon is also the non-consensual grounds of processing that has been provided very, very literally, not just in this draft, but also in the previous draft that we saw coming from meeting. And I think clause 13, which relates to grounds of processing, where it talks about particularly functions of the state. And I think that is and a broad set of reasons where consent may not be required. So when we talk about user rights, we're talking about user rights that essentially do 2 or 3 different kinds of things. At one level, user rights provide us transparency. They tell us, they give us access to information about what is going on. So right to access, right to confirmation in the EU, the much talked about right to explanation, which our draft doesn't have. They ensure a certain level of transparency, after which there are rights which allow a data principal to actually take some action. So right to portability, right to correction is based on having that level of transparency. But when we are creating a sort of legislative system where there are such widely provided exceptions to consent, then I think the meaning of some of those user rights becomes fairly redundant, in the sense that while it's not that those rights don't exist to non-consensual grounds of processing also, but their use becomes much more limited. The other point that I would make is that this bill is a curious mix of actually disregarding a lot of sort of knowledge that we have about how data protection should work and what has and has not worked. So, I mean, we're in 2022 now, and I think perhaps the biggest achievement of this bill is that we will have data protection law in India, like Linda said, and we have about 50 years of sort of international experience to look at, and I think that is the one advantage that anybody in India working on this law would have to gain from that knowledge, right? And a lot of, I think, sort of conventional wisdom about how data protection law should work has been disregarded. And in the context of user rights and surveillance, I'll specifically mention fairly straightforward things which form a part of necessity and proportionate framework, such as having, user notifications after the fact if you've been put under surveillance, for instance. And those are a sort of internationally recognized principle. So on the one hand, we've disregarded those. On the other hand, there is also this sort of ambition to sort of go for regulatory innovation and a hurry to adopt fairly untested legal provisions. For instance, something like consent managers, which we haven't really seen in much action so far. So, and also including it within the text of, including a framework like that within the text of the legislation itself, instead of perhaps waiting for a standard to emerge, which the DPA could consider as a regulatory exercise. So I think those are some of the key issues that I see with the bill, and I think particularly as far as the function, as far as state access to data is concerned, what Clause 13 effectively does is that wherever there is a function of the state involved, which is being implemented either by the state or a private party, it allows the state to completely disregard even the very sort of broken notions of informed consent that one might be able to implement. Even those have been treated as sort of temporary annoyances and can be disregarded through those provisions. So I'll pause there and wait for others to come.
Thanks, Amber. I'll come now to Prasanna, who's also an advocate, but who also describes himself as a coder turned lawyer. So a gem in MediaNama discussions who can navigate both the tech and the legal parts of the spectrum. Prasanna, you've been following very closely a lot of the work around government databases and how user data has been treated at this point very poorly. Right. So how does the bill address the sharing of data between the various government entities, and in your opinion, how does this impact user rights?
Thanks, Mani. Before we come to the text of the bill, how it kind of confers these powers to share between agencies with virtual impunity, it also, as Vrinda and Amber have pointed out, it is important to keep in mind that the flavor of the bill, right, that I'm studiedly using, not using the word stench, but flavor of the bill is now clear. So when Puttaswamy happened, it was about protection of privacy. When Sri Krishna Committee happened, it was about the protection of businesses, right? The shareholding of privacy had already been diluted by 50%. And now we do have, it's somewhere in the region of 25 to 30%, right? That's how the concern of the bill itself appears to be about privacy only for 30% or so, right? As if we first equivocated between protection of businesses, and now we have a further equivocation with the protection of the state, right? It's almost as if even before the bill is passed, the state has kind of exposed its deep insecurities, right? That's the expression that we see in the JPC committee report. And the carte blanche that Amber has written about and Vrinda have written about as well, that kind of it's there, it's almost there with every recommendation. You can see that that's the destination towards, like it's protect the state from the onslaught of this privacy activism, right? So that's so keeping that background in mind, if we look at user rights and if we take the framework, I mean, one way to look at it is negative rights and positive rights, like the panelists before pointed out. But there's also a kind of linear progressive framework where you say is first respect privacy, second is to protect privacy, guarantee and then protect privacy, and then to fulfill privacy and then to promote privacy. Where does this rank? Right? Does it even respect? I wouldn't say so. If we have to score it on a 6-point scale, right? We'll probably need to give it a 0. I don't want to sound sort of too extreme and crazy here, but that's the kind of flavor we do get this with this bill, right? It appears to kind of invert the whole logic, right? There is a certain logic by which the data protection bill came to the discussion around data protection itself. There is a historical context to it. We keep saying Puttaswamy. Where does Puttaswamy begin? It begins in the Aadhaar case, where the principal sort of bad boy is the government, right? And it's important that the government kind of puts itself under the scanner and makes itself amenable to all the regulation that it wants to advance to everybody. Also because we want the government to also be an exemplar. we want it to be the model data controller, right? I continue to use the word controller. We've had issues with naming all of the data controllers as fiduciaries right from the Sri Krishna days, right? So that I don't think that kind of captures the relationship between a data subject and a controller accurately. I think the dispassionate language of controller is much better. Fiduciary sometimes has the right to act in the interests of the principal, even if it is against the wants of the principal. We do not want those kind of conflations to occur. It is better to have it as a dispassionate controller. That's something that has been advanced, but obviously that has never been taken on board as yet. But so with this the background, so as I said, where there isn't even appears to be a respect to privacy. So although there is it does get a mention fair bit both in the preamble and afterwards. So the obvious consequence is that there is a virtual carte blanche, right? So in terms of not just sharing between agencies, but also under 35 for a government agencies to request from any data fiduciary any information they want that is necessary or expedient for any of the long list of purposes that is mentioned. So as I mean that would be the sort of only background that I want to give, so that kind of it's just a corollary of the whole framework that's been laid out.
Absolutely. But moving away from the state for a few minutes, I'm coming back to the rights of users vis-a-vis other data processing entities, which is largely companies. Right, Amber, I want to come to you. You referenced the GDPR and that there's a whole range of international privacy legislation, right? So how does this compare with user rights there in say the GDPR or broadly with global privacy standards? Abel.
So I think the structure of the bill from the very beginning has been, even though it's changed a little bit over a period of time, but it has largely followed structurally what the GDPR has. And I think in terms of the rights that are available to us, also, I mean, with some key differences here and there, I think they mirror what we see in most of the legislations across the world, whether it's the GDPR, whether it's legislations in California or in Canada. There are some key sort of differences that we see, but I think overall most of the user rights that you would expect a robust data protection law should have are present against private actors. The key thing that I would highlight is that increasingly, as we are grappling with enforcement of data protection law, I think broadly there is global consensus on key principles that should govern data protection law. There isn't as much clarity on how we go about enforcing that law, and I think there are sort of key innovations that have emerged. So one of the things that we saw with a lot of emphasis in the GDPR was on impact assessments, for instance. So I think that the sort of thinking behind that is that the notice and consent framework, which allows individuals to make decisions about their data, it often doesn't work because of the nature of information that is shared with them, the kind of decision fatigue that individuals face. They are not in a position to actually take those informed decisions. And increasingly what we are, so that is not a reason to disregard consent. That is not a reason to do away with consent and move to an entirely paternalistic framework. But what that requires is an incremental framework where on the one hand, you keep investing in consent and keep trying to fix it and make it more informed. But you also engage in activities where you look at certain kinds of processing which might be per se harmful, and you set a higher threshold for that. So I think in this version and the last version of the bill, we see the idea of harms and also interestingly significant harms emerging quite prominently. Again, that I believe is more it's more appropriate to have, while it's good to mention harms and it's good to mention data protection impact assessments or human rights impact assessment as key procedures that must be undertaken. I think how one goes about defining that harm is perhaps an exercise much better done by the DPA. And I think I caught last bits of the previous discussion where we spoke about practitioners and a competent team within the DPA being much better placed to actually looking at activities where you require that higher threshold. So I think that right now the way harms has been defined, it includes a lot of things, but we don't really know how that will translate. We don't really know what to make of it at the moment. I think there are some specific issues that people have raised about data breach notification rights and whether that needs to be intermediated by another authority or there should be, or all notification breach notification should be provided to individuals. I think those are key questions that perhaps need a little more thinking and amendment in this draft. There are also aspects, operational aspects of these user rights. So for instance, something like portability. Again, there we have the advantage of looking at least a few years of very detailed discussion on what portability should include. So the Article 29 Working Party opinion on data portability in the EU, for instance, has very clearly said that it includes what is volunteer data or observed data. It doesn't include inferred data. But we don't have that sort of clarity, for instance, in the emerging law. So I think one of the key challenges once this law comes into place will be regulatory clarity. We are currently operating in a state of fairly abysmal data practices, and this law comes in with several obligations on data processors. And there, I think the DPA will have to play a key role in providing that regulatory clarity. I think in sum and substance, when we look at user rights, there are key differences. One could argue, do we need right to explanation here? Some might argue that we don't need this version of right to be forgotten, or a limited right to erasure is what works better. But by and large, most of the key rights are there. It's more a question of how we go about enforcing and implementing them.
Right. On the enforcement part, actually, I wanted to ask you a bit further. There is already a lot of data collection that is ongoing. There are a lot of sort of very shady databases that have been collected by various companies and other private actors, right? Tried to make an attempt at addressing some of this with their DND notification database. Do you think the Data Protection Authority is more likely to succeed in this regard?
I mean, I think it is anybody's guess at this point of time. In the previous panel also, I think there was a lot of discussion on what is needed for the DPA to succeed. And I think people much better qualified than me spoke on this issue. On enforcement, I will say one thing, that the mandate of the DPA in India is going to be unlike any other regulator that we've had. If you just look at the jurisdictional scope of the DPA, therefore you need an authority with resources. You need an authority with a very clear regulatory strategy, and it needs to be responsive. So TRI is one of the more proactive regulators that we have. It's one of the more capable regulators that we have. Whether it will do better than TRAI or not that's a high bar to meet, and the failures that TRI has had, whether the DPA will succeed is a question that remains to be seen. But I do think that there is talent both within the government and outside of it, in the private sector as well as in civil society, which can. And if you look at if you just look at the discourse on data protection in India and how it has evolved in the last 4 or 5 years, it's extremely sophisticated. There are a lot of nuances that people in this space understand and have thought about. So that talent is available there. It's a question of leveraging that.
So then coming back, I have a couple more points to cover before we go into the Q&A. Lalit, I'm going to come back to you and to the second and third bundles of rights that you spoke about, right, in terms of obligations of the fiduciaries and rights of the users. Do you think that the new bill proposes a 72-hour notice requirement for data breaches, right? Do you think the bill does enough to protect users in that regard, both in terms of the obligation of the fiduciary and the rights that the user can claim?
Right. So on data breach notifications, there's actually the best way to approach this question is to look at a little bit of a comparative practice as to what are the timelines in other countries. And I'm afraid to say that I don't have a great grasp right now of what are the what are the number of hours, for example, provided in other countries by which time you're supposed to notify a data breach. I do think very intuitively that 72 hours seems like a lot. If you know that a breach happened and you're pretty sure that data of certain nature, it could be very sensitive data also, has been breached and it's now available to somebody that you did not think it would be available to. It could be publicized. It could be published at large. It could be in the dark web. Something could be going on with it. Why 72 hours is the question. I don't know whether you need that time immediately. Like, what's wrong with sending an email immediately? Will everybody be busy trying to handle the breach so you can't even bother sending a email to the data protection authority? Are you trying to figure out what is going on, which kind of data got breached? You're still trying to get confirmation. In which case probably you don't know that the breach has happened. At the point that you do know X data has been breached, I see 72 as a little long. And of course, the second problem with that provision is that it makes it completely discretionary upon the data protection authority to determine when person will have the right to know that their data has been breached. And there is a transparency provision, which is a broad obligation on all data fiduciaries that they are supposed to maintain transparency in particular kinds of ways. And that principle of transparency is further implemented through specific provisions in the bill, like notice and like data breach notification. So the data breach notification provision at present seems somewhat at odds with a broader principle of transparency, and perhaps even like a constitutional principle of what sort of transparency and breach notification would be needed for the government. Yeah, that's pretty much what I think about this particular provision. There's another duty though that I thought that's worth mentioning, which is a very general. We're at a stage when we're very close to coming to see the final version of the bill, where first principles seem like a little bit of thing of history. But I thought it's worth mentioning that there is one of the very general obligations on data fiduciaries, which is called purpose specification and purpose limitation. This provision somehow in further iterations after the Sri Krishna bill has disappeared somewhat. There is still some kind of purpose limitation that is there, but the provision for purpose specification has somewhat disappeared, and I think that's very worrying because it is a foundational principle of data protection. Think of it in terms of your general right. What is your general right of privacy supposed to do? It's supposed to ensure that if there is any violation of autonomous consensual use of your data, that violation should be minimal. It should take the mode that is least rights intrusive and should not disproportionately harm your autonomy or privacy. And that's how things like data minimization becomes part of a data protection bill, that you should only use that much data as is necessary for a purpose. So as soon as you try and figure out any way of bringing proportionality into data protection, a necessary feature of that operation is figuring out what the purpose is of you doing that thing. What the bill has done currently is that it's somewhat removed purpose specification, and it's got a purpose limitation provision that seems to equate purposes with grounds. In fact, it specifically refers to limiting your processing to purposes as listed in section 12. Section 12 is grounds. Those are very broad legal sanctions as to where and in what areas and what justifications you can use to process, but they do not meet the standard of purpose specification. A specific purpose is more specific than a ground. I'll give a simple example of where this sort of a concern becomes somewhat relevant. Purpose specification, I have always thought, is a considerable concern in a question like Aadhaar. If you think of a purpose like authentication, which is the purpose that is specified when you ask for consent when you're enrolling for Aadhaar, that purpose has always seemed to me a little too vague. Any kind of data processing which is aimed at identifying you as a person is a kind of authentication. So if that is the case, then we have a little bit of confusion about what kind of specificity is needed. The saving grace is that the notice provision, the provision which requires that you give notice to data principals, has a separate requirement that you specify the purpose and a separate requirement that you specify the ground. So that seems to indicate that they're different, but we have somewhat felt that these principles that some laws like GDPR have are a little too vague for us in India, so we have disregarded them. I think it's important for rights though, because you can't talk about rights unless you think of these foundational principles.
Absolutely. Thanks, Lalit. So my penultimate question is to Vrinda with regard to another set of things that Amber had mentioned earlier on the right to be forgotten. So in its current form, what do you make of that from the user? From the perspective of a regular user, what does this mean? And also the bill introduces some additional provisions in clause 17, which is that people have the right to leave some legal representation after death, right? So the rights of that people have the right to determine the use of their data after death as well, right? So do you see these as positive changes?
Yeah, so just to highlight, since we've been talking about like narrow rights and broad rights, so the chapter that deals with the rights of data principle essentially lists like 4 to 5 main rights. One is the right to access. So this is the right to know what is the data that you, a data fiduciary, is holding for me. And maybe what I'll just do with each of them is explain in just one line how in practice this might work. And we're already seeing this work in practice to the extent that companies will now start facing a lot of requests. So to some extent right now, companies may have a certain privacy policy, but nobody is doing that check of, look, what is the compliance with your privacy policy? What is the data that you actually have about me? Today, if I write to any company, they have no responsibility to respond to me. So when you actually have a statutorily enshrined right, I think it will make there will be a lot of compliance work from companies' perspectives in terms of now having to respond to maybe a lot of emails, especially the bigger companies, and to actually then be able to answer these questions. So there has to be some clarity at the back end. Right now, a lot of companies don't have that clarity at the back end. So actually, that's just right to access. And it is in this, as you mentioned, that there were 3 changes that were brought about. The first being that every user will have a right to nominate a legal heir or a legal representative as their nominee, which I think is a very good and a very progressive right. And I think you must absolutely have that. And I think it's important that they have both legal heir and legal representative, because they're actually very, very different. Heir is more, understood in terms of family, but when you have a legal representative, essentially it could be anybody making that request on your behalf. And so it could also be lawyers. You may actually end up seeing, I don't know if it will go in that direction, but you could see a lot of lawyers getting involved as like legal representatives. Then the user should have the option to exercise the right to be forgotten. I don't think this makes any difference. There was always this right even in the earlier bill. I think this is just another kind of clarification. And to explain what will happen in the case of death, which again, I think is very important. So to that extent, I think these additions are positive changes. The second is the right to correction and erasure. So interestingly, in India, right to erasure is not the right to be forgotten, although they're often conflated. Right to erasure has been used in the bill in the context of right to correction and erasure, which is slightly different from the right to be forgotten. And so correction and erasure will be very important, especially in like if you look at insurance or credit, credit scoring and those sorts of things. So you want to know what is the information that you have about me, about like, so what is the health data that you have collected about me? Is that something that I want to challenge or not? So that's right to correction erasure. Right to data portability. We've not really spoken about this, but I think this is, from a user perspective, it's obviously very useful that I can just move like we have mobile number portability, and it has made it very easy for us to choose a different service provider based on the service. The idea behind portability is that I will be able to choose any, assuming 2 companies are providing broadly the similar level of service, and assume you have things like data trust scores, which the bill does envisage, then I may choose a company that has a higher trust score. The issue I think here in terms of the change that was made is what they are going to do with trade secrets. And I'm not sure that the change that is made will actually work very well in practice in terms of saying now somebody will have to determine, you can't just cite a trade secret as a reason to deny it. Like you have to actually show that in terms of regulations. So we will have to see what that means. And then I come finally to right to be forgotten, which is going to be, according to me, the most used provision, possibly by all users. The way it's currently structured, and there's actually not a lot of changes in the new version also, but the way it's broadly structured is I can write to anybody and say that, look, you are currently disclosing or you are processing my personal data. This is an important change, the addition of the word processing. You are disclosing or you are processing my personal data. Please don't do that, because the purpose of which you had collected or processed the data is no longer necessary. So remove this from your website. And or that I had consented to this collection, I have now withdrawn this consent, or that you're doing it illegally. Now this application, because there is a recognition, obviously, that there may be a lot of frivolous requests, people may want to take down information that is like, that shows bad things about them, quote unquote. They say that, look, you can't ask directly any company to take anything down. You have to go via the adjudicating officer. The adjudicating officer will then decide what happens to your application. They will take into consideration, essentially, is my right as a user to prevent the restriction or the continued disclosure of my information overridden by the right to free speech or by the right of the company to use this data. So there are two separate overriding obligations. And then while making this determination, the adjudicating officer has to take into account like the sensitivity of data. So in a report, like MediaNama may have mentioned like the Aadhaar number. Well, I'm not in any organization has mentioned the Aadhaar number of a user. I think there's a very strong claim to say remove that, right? My Aadhaar number does not need to be mentioned. But if the report mentions the past criminal conviction of an individual, I think it's much harder to then make that claim. Where there is a lot of gray area is going to be, I think, two sets of things. One, either in terms of what we are already seeing in courts, which is that in all sorts of court records or records of proceedings. So to say that, look, the fact that I was involved in a court proceeding, that trial may be pending, but look, the fact that I got bail, my bail order is, uploaded online, I want that removed, because the moment anyone does a Google search, that's the first thing that comes. And so they think that, I'm still convicted or I'm still under process and I'm a bad person, so they don't hire me. So that is going to be one set of right to be forgotten challenges that are already going on in court and will, I think, get a lot more impetus once this law comes into force. And I think how you deal with litigation also has to be different. I think the parameters that will apply, and I would love to hear other people's views, but the parameter that applies, say, to an individual that has been discharged or acquitted, whether if they want that information removed versus somebody, whether it's a bail order when the trial is pending versus if it's a conviction. I think they are different stages and different considerations at least need to be thought about. The second is what is going to come, I think, to a lot of reporting organizations. Oh, that, why have you mentioned this about me? Or why have you mentioned this information about me? So it does not reach to the level of defamation, but you're essentially trying to short circuit an injunction order going to court by saying, please remove this, this is very bad, I'm going to threaten you, I'm going to sue you. And with many companies, the incentive to comply is very, very high, because who wants to go and fight something before the DPA? Before the adjudicating office, I should mention that if the individual, if anybody is not satisfied with the order of the AO, they'll file an appeal. So in that sense, you're not going to court, you're first doing this pre-court kind of, quasi-judicial authority, you're going before them. But I think there will be misuse, I think 100%. I think, yes, it is an important right. I have always been just a little bit suspect of how broadly it can be implemented. And the fact that people may really try and take down information. You don't like something being written about me. You don't like the fact that if I've said something now on a panel and that's been reported, you can't say 5 years later, oh, it's not important. It may still have important purposes. So I think this is a provision we all really need to think about how it's going to be used. And I think companies do need to take that stand and not just, over comply. If necessary, even if it's going to be expensive, obviously go before the AO, fight it out. But I obviously understand that cost considerations will probably ensure that doesn't happen.
Yeah, absolutely. If our history of companies dealing with copyright or even other takedown violations is any history, that is not very likely to happen.
In fact, I'll just add, just before Amber speaks, in fact, CIS had this amazing empirical study where they had done pre-Shreya Singhal, where they said that the notice and takedown, there was massive overcompliance. And, maybe Amber can speak about that, but something we even use in court, where we say, look, empirical research shows, and there's a lot of writing around it, that you could have made the most ridiculous requests, but it is just easier to comply because, frankly, from a company's perspective, it doesn't really matter if one name is there or not there, right? So, I just wanted to mention that as well.
No, absolutely. Amber, do you want to add anything before I go to Prasanna for the last question of this round?
I just wanted to add to what Lalit was saying earlier with regard to purpose specification. I think one of the interesting drafting choices that we see from the very first version of this bill with regard to purpose limitation is that the language that we see being used in something like the GDPR with purpose limitation is that of compatible purposes. So there is purpose that you've consented to, and it can be used for any compatible purpose, which means purpose that is aligned with what you consented to. In the three drafts of data protection law that we've seen in India, that has been changed to incidental purpose, which is a much wider term. The other point that I would make is about collection limitation. There also, I think the language that we see in some of the more robust laws is that the data must be adequate, relevant, and limited to what is necessary, whereas the language that we've seen in our bills is data which is necessary for the purpose of processing. And all of these terms have they subscribe and limits the ways in which data controllers are supposed to use your data, and they have, I think, over a longer period, we'll see them having very, very significant effect. So I just wanted to add that. Thank you.
Yeah, thanks, Amber. So then coming to Prasanna for the last bit, which is just drawing from what Vrinda said, right? We're likely to see, we might see a flood of requests to companies on the right to be forgotten and a few other things. But where do you see the big litigation happening around data, around this bill, both for the rights under the bill as well as regarding the bill itself? And secondly, I also want, if you can also touch on the new clause 62 that's been inserted into the bill, which gives individuals the right to approach the authority, a statutory right to approach the authority, which is like a sea change from, say, UIDAI, where until recently you couldn't even file an FIR for an Aadhaar leak, right? Yeah, go ahead.
Right. So on the first question, where do I see the litigation? I think there is the bill is a litigator's dream, right? So there is, in fact, we did I think the count of the number of times reasonable has been mentioned. I think it's about 40 times, if I remember correctly. So, and there are, or actually 25, I'm sorry. Reasonable, practicable, and then feasible, if you add them all together, I think there or thereabouts you get 40. And each of the time, and each of them is prone to litigation, right? And in all the cases, again, this concept of orientation with harm, this harm orientation and continued burden placing on the data subject to establish harm, establish loss or damages, as in the case of any civil action that continues to this day. That's again in section 64 and 65, clause 64 and 65, I must say, of the bill, right? So even to get compensation, I think that continues to be an issue, and that will again, in fact, one of the reasons when we wrote to the Sri Krishna committee, one of the advances we had made was that this needs to be taken away, because there has to be an incentive for people to file, and many of these harms are not foreseeable. In fact, Puttaswamy clearly says one of the reasons why privacy needs to be protected as a fundamental right is because not all harms are foreseeable. Forget about being able to establish that the harms have occurred. Right? So this placing of burden will in effect, it in fact means that all of the rights here, almost all of the rights here, will have to be litigated and won. It's not sort of rights that have been granted under the statute, which are there for people to realize and enjoy as in effect. So it needs to be effectuated only through litigation. That's what the predominant thing appears to be about. And 62, that there has to be that people can approach to a data protection authority with a complaint. I think that was a bare minimum that was required. I think the fact that it is there, I don't think requires any congratulations, right? So if that wasn't there, I think we would really not have a proper data protection bill, so to speak.
All right. We have some time for questions, I think, at this point. Nikhil, do you want to take over?
Yep. Thanks. Thanks, guys. Some questions that I had, firstly, that I want to understand from a user's perspective, and if anyone wants to take that up. Let's say my data has been breached, but the Data Protection Authority chooses not to allow the data controller to inform me, and later I find out about it. What do I do?
It's a very interesting question. I'm not sure I have a right answer for it, but the very preliminary thoughts. So you're saying that you didn't know at the point of when the breach happens, but you come to know later that there was a breach and the DPA had taken the decision not to really challenge it. I mean, I would say, what is the remedy that you're really looking for at that moment? Is it because I think that will really determine. Obviously, now against the DPA's order, you can always go to the High Court as a writ petition. But the question is, what effective relief can you really get? I mean, there is always a relief, what we call declaration. So just a declaration that what the DPA did was wrong. There can obviously be, you can't really ask them to notify you anymore because that relief is infructuous to some extent. You already know of what has happened. You could potentially say that direct the DPA to direct the data fiduciary to take action if you believe that has been inadequate. You could also, you could seek compensation, very hard to get in effective in Indian courts. But that is at least one just very preliminary thought that I would have.
Because
and I don't know,
as a data controller, I can
lawyer.
always say that I wanted to inform the user, but the DPA didn't allow me to inform the user.
I mean, there would be communication to that effect for sure, right? I mean, if the DPA is deciding, as long as there would be, like, it's not something they would be able to make up. The DPA would have to communicate to them that you don't need to inform to a user or something. So in that sense, the company stand will be very clear. I don't think you can really flip-flop on that, because as long as you have intimated to the DPA in advance and within the requisite period, and the DPA doesn't require you to inform the client, there is no obligation on you to do that. So I think that's why action would only be against the DPA if you believe that it was an incorrect decision. I'd be happy to see what others kind of have their view other than Ritz.
Next question. We're going to rush through because there's not enough time, and I think there are lots of questions. Say and this is my own case, we received a right to be forgotten request from someone who said that we'd covered the story about them, let's say 7 years ago, and that story is not really relevant anymore. And so therefore, can I remove their name from the story? And this comes as a right to be forgotten notice, because effectively, but for me, it's a matter of public record. What happens next?
I could try this one. There's one easy answer to this question, which is that there is an exception in the data protection bill related to journalism. So as long as you meet the conditions under that exception, you can say that, sorry, boss, you can't ask me to delete something. This is something that I'm processing, including publicizing, on the basis of a journalistic purpose. And the requirements under that to show that you are doing it for journalistic purpose aren't very strictly enforced. It requires some nature of allegiance to a particular code of practice and some kind of self-regulatory system that you have to be part of as a journalist, which most are, I think. And I don't think there's a very strict standard, but you have to be able to show that it was for a public purpose, that this thing was being.
Okay. If there is non-consensual processing of my data that's being done.
Can I just add to that? Sorry.
The other thing that would come up is that it's not a case that consent was there, that you consented to using. Sorry, yeah.
No, I'm sorry. I didn't want to interrupt you. Maybe there's a lag on my end.
There was a lag, Lalit. We lost you for a few seconds.
Yeah, I think there's a mild lag.
Okay.
Please finish, Lalit.
Oh, sorry. Okay, so I was just saying that in case it's not consensual, surely in many of these situations, if there's consent, the person can withdraw consent, and then you are required to stop publicizing or whatever. But there's actually a little bit of an issue with the bill. I realized we discussed right to be forgotten earlier, but it's worth mentioning that there's actually an overlap between the right to erasure in the right to erasure and correction and the right to be forgotten provision. In a sense, a person has a choice. They can go under the right to erasure and say that, listen, I said erase my name, and then you have to erase it. And then there is the right to be forgotten. And it's easy to forget that the word processing includes not just whether you have the data or whether you are publicizing the data. That is, you don't just stop storing it or stop publicizing it, but also if there's any particular operation you're doing on the data. The right to be forgotten, as it is currently phrased, can stop you from doing that processing, that particular kind of operation. That is a right now. It's not available in any other jurisdiction, as far as I know. The right to be forgotten is either about reducing publication or about removing from storage. It is not about stopping a particular operation. So I think in terms of policy making, there has to be a clear choice that is made, that when you want to erase data that is being publicized, you should be going under right to be forgotten. Perhaps the erasure provision should be entirely removed from where it is currently placed alongside correction and made only a question of the right to be forgotten, because there can be considerations of balancing rights, even when there is erasure from storage and not just erasure from publication. Or in just generally stopping processing. And a similar problem is there again if you look at portability and access to your own data is there under the right to access. Portability also allows you to get a copy of your data, but portability is not applicable against government. So if you want to access data from the government, which do you go under? Do you go under portability, where you're not allowed, you can't get it from the government, or do you go under access, which literally says that the government has to give you access to your data. This is a confusion. It's an overlap. I think both of these need to be resolved. But I think it also speaks to the problem that you're mentioning. Under what conditions will you have to remove it? Under right to be forgotten, you will have to remove it as long as your right to free speech in publicizing that data is not being disproportionately eroded. Under right to erasure, you don't have that. If somebody says that I want to erase my data, you don't require it for your purpose anymore. There's no balancing between different rights to be done. You have to remove it.
But as a journalist, isn't there an exemption?
That is if the journalist exemption applies to you. I then went into a hypothetical where it is not applicable. That's all.
And I would only add two things. One, that and this maybe touches upon a question that I think somebody had asked also, that in a right to be forgotten, you can simply say that you go to the AO and the AO will decide and we'll argue before the AO. I don't have to listen to you. There is no obligation for me to respond to a user request other than saying, please go to the AO under so-and-so provision. And then if you're unhappy with the AO's decision, you file an appeal, and where you'll do this balancing, etc., as Lalit mentioned. With an erasure, there is an obligation to respond. You can reject the request. But then that also under, I think, clause 58 or whatever, that will then be appealed before the AO. So the steps are slightly different. With an erasure, you will have to, if it is under that erasure clause, you have to respond. And then that can be, you can deny it, and then you have to explain your reasons for why you're denying it. And they have to, they will also require, there'll be communication, and the user will then appeal that to the AO. And in a forgotten case, you will have to direct them to mandatorily go before the AO. The AO being the adjudicating officer.
So Shravya has a comment or a question, as a question for both of you, Vrinda and Lalit. The new changes by the JPCs need the AO to also balance the right to be forgotten against the right of a company in addition to freedom of speech. While the balancing against the freedom of speech is well accepted, the balance against the rights of the company seem a strange addition, especially given that the Google Spain case that specifically held that right to be forgotten trumps the right of the company. Wanted to know your thoughts on this. Vrinda, then Lalit. You're on mute, Vrinda.
Could you just repeat that? My charge had gone, so I was just trying to charge my laptop. Could you just, or I'll just read the question, and maybe Lalit can.
Lalit, you want to go?
Yeah, I think this is just a symptom of what happened when they included the word processing within the right to be forgotten. Originally, the right to be forgotten was very cleanly drafted, and it was indicated that the right to be forgotten is only about publication. And therefore, the appropriate rights, the contrary rights, the rival rights against which an adjudicating officer has to balance the right to be forgotten was only the right to free speech and the right to information of individuals. Now that they have added in this provision that you can request a data fiduciary to stop processing something. Stop processing includes stop storing also, in a way. Storage is a kind of processing, but maybe erasure is the better home for that. I don't really know anymore. But if that is the case, then yes, the only standard that you have in relation with stopping somebody from processing is the standard that the law itself provides, which is that you have to have a ground for processing it. If you don't meet the requirements under the ground, then you should stop processing, and somebody can request you to stop processing. Ordinarily, how did a person have to do this? Ordinarily, a person would have to go not via your requests under the data principal rights chapter, but through a grievance redressal officer system for a violation of the law. You have to approach the grievance redressal officer and say to the grievance redressal officer that your company has violated this particular provision of the law. Not a data protection right, not a data principal right request, but simply that you have stopped, for example, stopped using the data for the purpose that you mentioned. You are now processing the data for another purpose, let's say. It's a violation of the law. You approach the grievance redressal officer. Now you don't. Now you have to go, you can also go via the right to be forgotten. It's kind of strange. Somebody violates purpose limitation, but you're going by the right to be forgotten and stopping them from processing in another way than was originally specified. So yeah, this is a symptom of the fact that we have pushed processing into the provision, not earlier the case. And one possibility of a threat that is there is that in adjudicating questions related to the right to be forgotten in case of publication, where you're only supposed to balance for right to information and right to free speech, you bring in that other thing, which is something about the right to of the person to process data, the right of a data fiduciary process data. That shouldn't be relevant in that sort of a way. All in all, there's also that provision which says in the general conditions for the exercise of the rights that a data fiduciary can also refuse your right if it is, harming the rights of some other data principle. I think this is a place where there will be a lot of problems as well when it comes to where an individual can say that they have the right to continue processing. A data fiduciary can say that. They can easily claim that this is somebody else's right is being violated. So that is something where greater clarity will be needed. But yeah, to the question, yes, that's I think that's the source of that drafting problem.
Just to give an example, I'll keep it very short because I know we're very short. You look at what's originally there, which is the right to freedom of speech and expression. That would be like, say, in a case where I'm reporting on like a scam, right? So there is an important public interest in the right to know and the right to freedom of speech and expression that should justify the reporting. The second part that was also earlier there, right to information of any other citizen. That's what Lalit has already spoken about. The third, the addition, is the right of the data fiduciary to retain the data. One example of what this might be is so if I have consented, so when I'm speaking here, I'm consenting that you are going to report my views. If I have consented, do you have a right to then use that? And how does that operate if I don't withdraw my consent, but I'm just sending you a data forgotten request? So that may be an example of those kinds of things, maybe what could be, your right to retain and process my data. So I think, and because it uses the word retain, use, and process separately, so there may also be a holding that you don't have a right to disclose, but yes, you have a right to process. Like the company should still have a right to process, because otherwise it's very hard at the back end to manage data. So
I think they forgot that under the bill, retain and the other word that you said come under processing anyway.
Everything comes under processing, which is the problem.
It is redundant. Shrija has a question saying that the NHA has been issuing several policies, including the health data management policy and the recent consultation on the proposed health data retention policy. Will these need reconciliation with the Data Protection Act when it's passed? And will user rights be any different in the multiplicity of laws and policies? Amber and Prasanna, do either of you want to address this?
Yeah, unfortunately, I think we may need to wait for that. I mean, this data protection bill presently has an override, right, over all laws, right? So I don't know if therefore it would be read, or whether that would be a governmental purpose which would be exempted under this. So we need to. I don't have a ready-made answer right now. Amber, if you can.
No, I mean, I would actually say that it would have to be reconciled with this data protection law in its current form also, because even if you go under non-consensual processing for some of these, because it could fall under quote unquote functions of the state if it is shown that it is authorized by law. Even in that sense, the obligations on the NHA or allied bodies as data fiduciaries would continue to apply there. So I think all of that would have to be relooked at and would have to be aligned with the provisions of this law.
Thanks, Amber. Lalit, there's a question for you that you were talking about the relationship between Clause 4, which is specific, lawful, and clear, and Clause 12, which is grounds for processing. Can you also discuss how Clause 4 and Clause 5, which is also touching upon purpose limitation, will work now? You're on mute.
Yes, sorry. I think what Varun is asking is in relation with 4, which earlier read that the processing of personal data, the 2019 bill and 2018 bill, they required that the processing of personal data be for a purpose which is lawful, clear, and specific. And what I mentioned earlier was that this was essentially where the purpose specification was. This was the only place in the bill which required that when you process data, that purpose for which you process data should be something which is specific and not just a ground like function of the state. It should be a specific purpose against which you can map what is or is not necessary for that purpose, right? You can say something is necessary for a function of the state and people will be like, all right. But if you say something is necessary to provide rations to an individual in a way that does not allow pilferage, if you make that your purpose, then there is a better test that you can apply to see what is and is not necessary, right? So that provision is now gone. That provision which said that purposes must be specific. Now there is only a provision which says processing of personal data shall be subject to provisions of this act and the rules and regulations made thereunder. This provision is entirely redundant. And now there is no reason to talk about the relationship between 4 and 5, because this provision has a relationship with everything. It is basically saying follow this law. There's no point to say follow this law because all laws are supposed to be followed. Basically, the JPC has missed out on the importance of purpose specification and found it vague, and so has just put a provision which is redundant. That is what has happened in 4 and 5. I had a quick point in relation with the previous discussion. The previous question, which was about compatibility between prior policies and laws and the existing one. I realized that we have discussed the government function, that particular non-consensual ground of processing, which says that there are functions of the state. I have noted that across these last 2-3 years, this particular provision has been viewed with considerable, distrust about what it means and what it says. I just thought that it's worth mentioning that there are some things which definitely will require compatibility. It, for example, says that if you go under this provision, it has to be authorized by law, right? That's what section 12 says, that if you want to use a function of a state as one of the ground, you have to authorize it by law. And that is not the case with NDHM as currently stands. So as soon as this law comes in, NDHM will have to have a law put in place, suggesting that this kind of processing is now authorized. And this authorization will have to be necessary for the purpose. That is again a requirement under 12. It has to have a standard of necessity. The standard that is required under the Constitution is now also in the bill, necessity. And lastly, all of this will have to be not just for anything, but for the provision of some service or benefit or the issuance of some certification, license, permit, something of regulatory or something welfare state related. So this is the way in which this law has limited, and to that extent, it is not a carte blanche. I at least consider so, not a carte blanche regarding government involvement in personal data. The difficulty in drafting such a law and in relation with regulating the government in relation with the use of personal data has been that it is in the end a statute. And in the future, the government can wake up and say, hey, I'm going to pass a new statute, and this new statute is going to override the data protection law. Regardless of what the data protection law says, I'm going to have a new law. It is not possible to regulate statutes through a statute. And therefore, we have this kind of a broad looking provision, which as it happens is analogous to the other provisions in other jurisdictions. So I don't think it is a zero or a carte blanche in relation with regulation of government functions. It is a necessity, and it does the minimum that is required. And further clarifications will probably come through codes of practices and regulations, which have to relate to this particular provision, this particular non-consensual ground. There will have to be compatibility of past laws as well.
So, I mean, as a user, how does this impact me, and what rights do I have?
Take an example like Aadhaar, for example. Let's say Aadhaar. Let's just see how the Aadhaar system has been impacted by this law or will be impacted by this law. Number of people, millions of people gave consent to Aadhaar. They entered and enrolled into the Aadhaar system by giving consent. Now that consent is not going to be the standard of consent that is required under the data protection law. If that consent has a continuing effect, the continuation of that consent is now invalid because that consent doesn't hold up to the standard which the data protection law requires, especially for biometrics, where the standard of consent is much higher than for normal consent. There is also the requirement that you can withdraw the consent now. So you can effectively, under this law, withdraw the consent from Aadhaar, and that withdrawability has to be as easy as it was to give the consent. Then
so the first thing we're likely to see is that an exemption for the UIDAI will be created.
That's what we have to be afraid of. Like, if you wanted a lot of provisions in this bill regulating the government, it's difficult to look at this as a political economy question, but that's how we have to do it. Make this into too big a package deal, and the government is likely to, just dismiss it. It's important that this bill be a little measured on that front, so that we can incrementally come to the position where there is proper regulation of the government use of data.
Prasanna, do you agree?
Yeah. So, I certainly don't agree that that's not a carte blanche, because 12 alone is not the only place where government has its way. Right? There's 12, there's 35, and the place where there are whole organizations could be exempted. Right? And also potentially, there is a later law that comes. Right, and you can put. As Lalit indicated, so there are going to be two laws. So it is very well that a judicial interpretation would say that because that is the special law that will override. Right. So we are still. Yeah. So that to an extent, it's correct that not all problems are going to be solved by this bill. Right. But having said that, so this bill has enough of a flavor because it's not just, as I said, it's not just the text of the bill, right? It's the overall reading of the bill that you see. And once the object says that it is not just, when there is security of the state, etc., right at the object, then it is very easy for a judicial authority to come to a conclusion that this bill will have to give in to any other law that comes in, either through subordinate law or through plenary legislation in Parliament.
Amber, you wanted to add to this?
Yeah, no, I just wanted to add that I think with regard to authorized by law, we might be overstating the kind of oversight that it might provide. Because see, what is required under this is that the function must be authorized by law, which means that the law must authorize a broader activity that the state is undertaking. That doesn't mean that the specific kind of collections that we're talking about or specific kinds of processing that we are considering must be authorized by law. So I think that is where I'm distrustful of the authorized by law or its utility in this case. I think on the broader point that Lalit made, I would have a disagreement. I think there is a political economy of interests here, both in terms of state interests and industry interests. But in this particular case, when the genesis and the mandate of this bill draws so very directly from a constitutional right, I think it is the duty of those tasked with drafting this bill to protect a draft like this from political economy considerations. At least that's the ideal that I would like to see here. And obviously, in practical terms, we may not see that, but I think that's the ideal that we should try to hold those tasked with it to account for. The other thing that I would say is that maybe I misstated myself. I don't think that previously provided instances of consent will be invalidated by this bill, but I think something like NHA, if it is authorized by law in the future, any subsequent collection and processing then would have to comply with this law. That's what I meant. That doesn't mean that 130 crore people who enroll for Aadhaar now have to enroll again through a new form of consent.
I think Prasanna wants to respond to you.
So one thing, the interpretation that Amber is giving for what is authorized by law, whether the function needs to be, I think let's wait. I mean, if this becomes an act, maybe we'll actually give a different interpretation to it. And number two, section 12, clause 12 that Lalit has been telling us about is also, this is not just for the state. So any function authorized by a law where the performance is necessary, it could also be by private actors. So in which case, the entire ecosystem would in effect be able to make use of section 12 and to claim an exemption under 12. So that's something that we must keep in mind.
And I'll just add to that on 12. We've not really discussed that, but just to add, interestingly, in terms of language and drafting choices, like if you look at the Aadhaar Act, after the Supreme Court's judgment, essentially had to read in like what is the meaning of benefits, subsidies, and services, and connecting it to the Consolidated Fund of India, right? Like that link that limits this to Consolidated Fund of India services doesn't exist. So just like, that also is a factor that needs to be considered.
In what way?
So what will get covered under section 12, right? So under Aadhaar, after the Supreme Court's judgment, it was very clear. That's why if you remember all those scholarship schemes or like the yoga kendras and all, they said you can't link Aadhaar, you can't mandatory link Aadhaar, because that goes beyond the understanding of subsidies, benefits, and services, which has to be tied to those services that are funded out of the Consolidated Fund of India, right? There is no similar requirement under clause 12 that the services you're talking about or the benefits you're talking about are funded from the Consolidated Fund of India. So there is no inherent limitation that is built into it. So technically any program could come under, or a much wider definition of programs could come under clause 12. So if you remember what happened before the Supreme Court intervened in terms of mandatory Aadhaar, right? Like it was being made mandatory for like a CBSE exam. It was being made mandatory for like some yoga kendras, I remember, and some teacher unions, etc. So that was all structured. Yes, exactly. So the question is, the court made it clear, unless it is funded by the Consolidated Fund of India, section 7 of Aadhaar cannot be read in this, like mandatory provision cannot be read so widely. So I would argue that even that limiting provision doesn't exist in section 12.
Just a quick clarification, would you say that was linked with the money bill requirement, which would not be applicable in all situations?
I don't think so, because that was linked to more yes, partly, obviously, but I think not necessarily, also because when you're looking at what is mandatory, so whether something is introduced as a money bill, yes, it has to be welfare and services. But I think when there is also this idea about like, what can you really make Aadhaar mandatory for, right? And if you look at what it was made mandatory for, they said it can only be made mandatory for welfare services and not all of this kind of CBSE exams, But yes, the fact that it was a money bill, I mean, we can disagree on like the court's interpretation of money bill is obviously like it's contested, but yes, definitely that did play a role. But I think in that sense, it is important to have a limiting factor about what the services can be used for. And yeah, so I mean, I think to clarify, yes, I do think money bill obviously played a factor. It would be kind of, I think, incorrect to say it played no role.
I don't know if we covered this one, but how does the expansion of harms to psychological manipulation help users? Does it help users? What sort of what sort of a situation does it create? Can anyone think of examples?
Just a quick point to at least put it in context. This word of harm, the definition which is there, it has also been considerably criticized across the board. When the first bill only came out, there were issues with it. It seemed to talk mostly about tangible harms, and then finally, to some extent, relation with reasonable expectations. I think that's the only thing that was there. Now we have psychological manipulation. Where does this word harm, which is defined in the definition clause of the bill, get used in the bill in the first place? There are many rights, I want to clarify, which are not contingent on there being harm in that case. Violations of the law, for example, the fact that you do not have a ground under which you're processing without a ground, you're processing without doing purpose specification, you have exceeded the requirement under data retention, you're storing data beyond that period of time, you're doing all kinds of violations. All of this is rooted as being actionable through applications or complaints to the grievance redressal officer, data fiduciary, which is appealable to an adjudicating officer. None of them are directly linked to a requirement that there be harm proved. Only for compensation, where there is monetary compensation required, you have to show that there is some nature of harm. And I think in that nature, it will be difficult when they try to evaluate how to calculate that compensation. What is what is the harm of a bigger magnitude? What is the harm of a smaller magnitude? And I see a lot of issues with that. But it makes sense that some nature of harm has to have been shown, because it's not possible to compute any kind of compensation just because of violation of law. Other places where harm is used is in those places where the law has to take part in some balancing act. For example, when they're looking at sensitive personal data, trying to define new kinds of sensitive personal data, when they're trying to define the possibility of a significant data fiduciary. It's in these places where measuring, balancing becomes necessary, where some kind of a quantifiable requirement like harm seems to have appeared, because it is difficult to look at it in terms of imperative categories like rights, because there is some nature of balancing taking place. So I think this misconception about harm being so problematic, this conception about harm being very problematic, can be a little measured. There are instances where it might be problematic, but not everywhere.
Okay, we're going to have to close, but one quick round of comments from everyone. And I know Prasanna wants to respond to something, but a quick wish list, starting with you, Prasanna. What needs to change?
I just wanted to round up
what needs to be added?
Only because Lalit mentioned harms again, and how for compensation. In fact, we want the principles of compensation because we understand privacy is a fundamental right, somewhat of a sui generis nature when we are trying to look at arriving at the principles of compensation and theory of liability, right? So that needs to be developed. There's no question about that. And to have harm at the center of it as though only after the establishment of laws. So that actually goes against the very the Puttaswamy dictum, as well as something that we've understood privacy has generally. Because foreseeability, because anywhere, for example, in any civil action, right, what is awarded, for example, when we say only direct damages are awarded, so only those to the extent that are foreseeable. But what do you do with a right that is by definition where the harms are not foreseeable? Then we will have to have a separate compensation measurement mechanism, much like how we have penalty computation mechanisms, right? We will need compensation mechanisms which will then incentivize users to actually litigate for privacy. When you have a bill that is particularly put a lot of the onus on the data subject, our point is that the compensation scheme must kind of divorce itself from the harms orientation and get to an injuria sine damnum standard, as we say.
I have no idea what that means.
Yeah, it is where it is a recognition that there is a legal injury that has happened, okay, and the damages take a backseat. You don't have to necessarily establish the losses that you've suffered in order for you to be able to compensate.
Okay. Now, without the Latin, Prasanna, a quick
Nikhil,
wish
sorry,
list.
I want to intervene before Prasanna responds because I have another conference that I have to go for. So maybe Prasanna can give his wish list. Three big things, I think. Surveillance reform. I don't think that's going to happen at all, or at least some amending of 35 and 36. So it's a complete wish list, but nothing is going to happen.
What amendment?
Oh, I would definitely restrict 36 and remove any private parties from being able to take that exemption. I would add a lot more like necessary proportionality language. I would hem in the exceptions in the sense of you can't exempt the entire application of the act. You would still need to comply with fair processing and those sorts of things. I don't see why you should not comply with fair processing. I would also, I think, really change try and improve the structuring of the DPA, both in terms of having more offices. So not just in Delhi with 6 people as whole-time members, but a much bigger organization. I think in a country like India, you cannot have one Delhi office. It's just not, yeah. And I think the third is I would probably try and remove non-personal data from this, go back to that PDP kind of standard.
Well, my wish list was from a user rights perspective.
Oh, from a user rights. Well, I mean, I think both the first and the second are important from user rights. And I think the only other thing would be, I think Lalit had already touched upon that. I would remove this conflation between erasure and right to be forgotten. I think it's going to create a lot of confusion in practice. So you should have one right. So if you have a right to be forgotten, you kind of make right to correction and edits only that. Because in fact, even in Puttaswamy and Justice Shah's report, they were never put together in that same manner, I think, in which they're now reflected in the bill. So yeah, I think that's it for right now. I'm really sorry, but I have to leave because I have a conference. Thank you so much.
Thanks, Vrinda. Prasanna, wish list from a user rights perspective.
I think Vrinda has spoken for me. I'd stick to that. Thank you very much.
Okay. Amber and Manish, if you have a wish list, we'll come to you as well.
I mean, I would echo some of Vrinda's wishes. I'll also add to what Lalit mentioned earlier. I think bringing back purpose specification and collection limitation provisions, which have now been removed from the bill, I think that would be one big thing. And then the thing that I keep harping on, completely redrafting clause 12. I think that is, to me,
how would you want it redrafted specifically?
I think extremely limited non-consensual. There should be limited situations such as vital interest when there is a great threat to life. There could be limited situations where we clearly define legitimate interests and then allow for non-consensual processing based on that. As far as functions of the state are concerned, I think I don't have a clear articulation of what that standard must be, but that has to be a much higher standard than what we have right now. The other thing is that the word necessary has been used in the 3 versions of the bill multiple times. It relates at various points to user rights. And one of the recommendations that we'd made is, given the fairly trivial amount of jurisprudence on the word necessity in our jurisprudence, and the much greater amount of jurisprudence on the word proportionate, we had at each point recommended that it should be necessary and proportionate at each point. So that would be the big sort of overarching change that I would want.
Lalit?
I think most of it has been covered by what people surveillance, the fact that the rights also depend on the independence of the Data Protection Authority. These are the 2 main things that are missing from this bill: independence of DPA and surveillance requirements. So far as the non-consensual grounds, other than the Section 12 goes, I think that the place in which we should look forward to changes is maybe in the bill. There could be some changes in the bill. Data breach notification separately, just bringing it up, flagging it. But I think that much of the non-consensual processing grounds, they will see the actual restrictions and the actual norms coming up when we have proper good regulations about it. I recall that there was consideration that there be specific requirements that each department of the government come up with the terms on which they have to do processing in their department. That's basically the difficulty with putting in government checks in the data protection bill, the difficulty in putting governmental checks, because there's so many different ways in which the government could be using data that it's difficult to talk about each kind in the bill. I think regulations, codes of practices are where we should be seeing that coming up. Again, the DPA's independence will be problematic there.
Thanks, Lalit. Manish?
What the others said, plus I endorse from the previous panel that the DPA is largely going to collapse under the weight of its own functioning. So some of its functions under 62 really need to be moved, like one of the audience members said, to adjudicating officers and to other bodies. Otherwise, it's simply not going to be able to sustain the volume of requests that Vrinda and the others indicated it's going to get.
Thanks, Manish, and thanks for the great moderation. Thanks, Vrinda, Prasanna, Lalit, and Amber. I'll hand over now to Vanisha for what I hope is going to be a pretty hotly discussed panel on government access to data. I know we've actually discussed this across multiple sessions, but in more detail over here. Thanks, everyone. Vanisha, over to you.
Thank you, Nikhil. It's great to be here, and it's been lovely to hear the other panelists, and been a very stimulating discussion so far, and I hope that this one continues along those lines. To begin with, let me introduce the members on the panel. We have a great panel here. We have Anushka, who's done a lot of great work on surveillance and transparency and is part of the Internet Freedom Foundation. There's Chalak, who's the Executive Director at the Center for Communication Governance at NLU Delhi, and Saikat, who's the founding partner of DeepStrat. So welcome to the panelists. Before handing it over to them, I'll quickly introduce the topic. Today, we're talking now about government access to data. As Nikhil said, I believe this has already been referenced in multiple panels. The previous one just referenced in detail Section 12 of the Data Protection Bill. Along with that, I think what we should focus on a little bit more is Section 35. Section 35 is a very broad exemption that has been given to the government to exempt government agencies from the application of any or all provisions of the Data Protection Bill. So let's unpack that. What that means is, while the Data Protection Bill comes in light of the Puttaswamy judgment, which talks about the individual right to privacy and the informational right to privacy, extending not only against the state, but also against private players and non-state actors. What 35 does is actually provide a carve out whereby the central government can exempt government agencies from the application of provisions as foundational as those relating to consent of the individual. And we'll see through this panel how that can affect the right to privacy itself. So first question, Anushka, can you give us an example of how Section 35 can be used to collect sensitive data without consent? Do you see that that enabling surveillance in any way, or how does it affect individual rights to privacy?
I think it definitely does enable surveillance, and it's very disappointing because, I think everybody was hoping against hope that the PDP bill would actually end up reforming the surveillance provisions in India. But what Clause 35 does is that it says that the government can, as you said, the government can exempt its own departments from the very application of the law itself. And these exemptions can be, the standards for these are necessary and expedient. So these are very vague and broad standards. I mean, expedient can mean anything which is necessary, which is useful or practical, but it does not mean, it can mean that it's also morally improper. So in a situation where the government thinks that, for example, for national security, it is expedient to carry out mass surveillance through facial recognition technology, it can use the Clause 35 exemption. And I'm pretty sure it's going to use the Clause 35 exemption to exempt authorities such as probably the Delhi police or the NCRB, which is going to carry out facial recognition surveillance. So that is how I think it's going to work out, how Clause 35 is going to affect privacy in terms of surveillance.
Right, and taking that one step further, can you give us an example of how facial images or biometrics may actually be used as some sort of an ID proof where it's made mandatory and where consent is not really made as relevant?
Yes, definitely. So, for example, if we're talking about the DigiYatra program of the government, which is basically what they plan to do is the Ministry of Civil Aviation has launched this program. In that, what they want to do is they want to make air travel paperless. And what they want to do is that they want to make your face your boarding pass. So everywhere, each of the checkpoints that you usually go through at an airport, you won't have to do anything. You would just have to show your face. And for this, the enrollment process is that you share Aadhaar or any other government issued digital identity card. You go to the airport and then you verify your face against that digital identity card, and then you use your face. Now, the policy document for this scheme, first of all, it does not have any force of law, but then it also, while it does talk about provisions such as purpose limitation and that the data will be deleted after the flight is over. It does say that if any security agencies or any government agencies want this data, then they can change their data purge settings or data purge security standards. So again, I think this is, and if they then, apply clause 35 here as well, then that is how it's going to happen, wherein, you gave your facial details or you connected your Aadhaar or any other identity card and you gave your details there, and then now the government is actually using it to track your movement across the country, which can result in problematic situations, and it can also end up violating your right to travel freely throughout the country.
Right, and that's very interesting, I think, because the same sort of leeway will not be given to private entities or corporations under the bill, right? Private entities will be held very strongly to the purpose limitation kind of framework or protections that the bill actually seeks to put in place. So that's interesting. Saika, just taking off from there, can you speak a little bit to how the government has actually been accessing data for citizens, as well as, data that relates to foreign individuals that's stored in India, and how does the bill impact that?
Thank you, Manisha. I hope I'm audible.
Yes, you are.
I agree with what Anushka has just said, and she's explained very well how 35 can be misused, etc. If you look at the current structure, the history of surveillance, first of all, we have the Indian Telegraph Act, and then we have the PUCL versus Union of India judgment of December 1996, where some modicum of safeguards are put in place, etc., which become Rule 419A, etc. The gist of it today is that, for example, if somebody wants, say, your data, how is your data identified as yours is either through a telephone number or an email, which are then you can be put under surveillance, and your phone number is put under surveillance or your email is put under surveillance. First of all, what is the procedure which will then ensure that whatever you are or your data is under surveillance, is it required or not? All that decision making is taken by basically one person, and that happens to be the Union Home Secretary if it's a central government agency, or the State Home Secretary at the state level, where, first of all, even if they are to follow all the so-called legal norms that are currently existing, they can just do it at the stroke of a pen without any deliberation on why Vanisha's records are needed, why she has to be put under surveillance, etc. So this is the first level. And just to give you some numbers, we've been filing RTIs, and I remember I almost 7-8 years ago when I filed an RTI, no, actually longer before that, I think 2008 or 9 or probably just around that time, the data given by the government under right to information said that they are going to be looking at 100,000 telephone numbers which are put under surveillance in a year, which translates to about 9,000 a month, which is 300 a day. Now imagine one person, the Union Home Secretary, having to look at 300 requests besides the whole galaxy of things that person has to deal with. And what is the kind of attention that will actually be paid? So first of all, there is no protection when this is sanctioned, and suddenly all your data is being viewed by some agency or the other. The law also says that after 60 days, it has to go back to a monitoring committee to justify whether any of this material yielded something or not, and is it justified to carry forward that investigation. which again is done by another set of bureaucrats slightly senior to the Union Home Secretary, which is the Cabinet Secretary, with two colleagues who are of the same rank as the Union Home Secretary, which is the Legal and the Telecom Secretary. What this decides is, again, they have to go through some thousands of numbers and emails within a space of few hours, where you also have to leave some time for tea and snacks, etc. So you have no, for giving access to this data, there is no procedure which actually works, or thought process or justification, and then there is barely any monitoring to speak with. In a situation like that, you have brought in the data protection bill as we look at it, where they are now giving a full exemption to anybody that the central government or the state government thinks is good enough to go ahead and access that material. As a result, and if you look at certain other things, and I think the JPC report I think unintentionally makes it much more obvious. For example, if you read the clauses on data localization, they say we need data localization because the law enforcement and the central government needs it. And why do you need it? So they also say, and who are the main stakeholders for that data localization? Government and law enforcement come before citizens and residents. So they are making it very clear that if you read this with what exemptions under 35 and also 36, they are making it very clear that they want access to your data. They want to keep it. They want to keep it for as long as possible, and it can be fished out and given to, can be used for whatever purposes it is done, without any judicial oversight, without any parliamentary oversight. As a result, what will happen is that they can access practically anything of your data and then use it for whatever purposes that they want.
Right. Thanks, Aikat. I think that that's a very comprehensive look into, the history of how this has been being used, and how giving such a broad exemption really can be used very, very broadly. And that brings me also to a point that you raised, which is kind of putting the state sort of at the center as opposed to the individual. Unlike what Puttaswamy did, which reiterated that, hey, you have the fundamental right to privacy as an individual. And so, Jhala, can you speak a little bit to where does the individual even figure in Section 35, if they do at all? Because what if the state were to requisition an exempted government agency were to requisition personal data from, say, a body corporate or a company to which I as an individual have given data? Does the individual's consent figure at all in that transaction? Do they even get informed? And what happens if once that exempted agency has collected the data, can they share it with other agencies? Can they share it with other exempted agencies or just about anybody? What happens in case of a leak or a disclosure of data by the government? I mean, we know that's happened quite often in the case of Aadhaar data, etc., by the government. So are there any protections at all for the individual when government accesses data in these ways?
Thanks, Manisha. And it's great to be on a panel with Anushka and Saikat and be discussing this issue. I think sometimes I feel like we're a broken record, and we've been talking about these issues for the last so many years. And we have yet another version of the bill before us where we're again reiterating these issues. And I hope that we see some change and shift. But I think, Manisha, coming back to your question, I think, let's start with let's start with Puttaswamy, where the right to privacy sort of flows out of, where we have some tests and benchmarks that the judiciary has set for us. And sort of one of the key tests, and I'm not going to iterate all the tests, is the necessity and proportionality of the action that the government is undertaking when they are taking any action that has implications for the privacy of an individual, right? Now, what does necessity signify, right? If we go back to the way the court has looked at it, the way international jurisprudence is developed around it, necessity is, basically when there is sort of a legitimate aim, and this interference with the right to privacy is sort of required to reach that aim, right? The bill in Section 35 does have the language of necessity, but with that, it has the language of an expedient. I think Anushka was highlighting what some of the challenges with the use of a word like expedient could throw up for us. But actually, if we go back to the language of Puttaswamy, which actually uses the word proportionate, and we try to sort of peel apart what does proportionate signify, it basically it's something that is appropriate to protect the legitimate aim. So it's sort of the least intrusive instrument that you can use to receive that desired outcome or result that the government is working on. So I think, one of the challenges is that the language in the bill doesn't align with the language of the court. And I guess one of the biggest questions will be is if the right to privacy of an individual is enforceable against the state, which it obviously is, why is a provision which is exempting the state from the application of various data protection principles not complying with the standard that has been very clearly articulated by our courts? And then I guess the question arises that if this passes into law, it is prima facie, it is very likely that it's going to be challenged in court, and it's fairly likely that the court is going to hold that this is sort of unconstitutional and doesn't comply with a very, very basic standard that the court has sort of laid down. Now, there's been a lot of chatter, about the fact that in, the recent version of Section 35, there is an explanation clause which says that such procedure has to be just, fair, and reasonable, and a proportionate procedure. But that's just the procedure by which the government decides to exempt something, right? It's not the overall decision to exempt, and I want people to sort of keep that distinction in mind. I don't want to keep going on about this because I think there's like no end to talking about this issue, but I do want to leave people with the thought that this doesn't comply with the standards laid down by Codifying. And secondly, in a law, and drawing from what Saikat has said, that in a law where the regulator is not very strong, we have 6 members, right? What are 6 members going to do against the quantum of stuff that's going to come up before the authority? There are questions of independence and accountability of the regulator. And then coming, Manisha, to your question of what happens when there is a data breach. If you look at Section 80, Clause 86 of this iteration of the bill, it basically says that where there is a government data fiduciary and there's a breach, the head of department of that department will sort of take cognizance of the matter and, sort of investigate. And then the question becomes that, okay, the government is sort of being a judge in their own cause. Why are they looking at this? Why is this issue not going in front of the authority? It's not very clear what role the authority is going to then play in sort of any sort of collection of data by the government. I mean, the lines are very blurry and gray, and it could go, this way or that. But I think it sort of, the bill sort of leaves you with a sense in the way various provisions are constructed that in many ways the government has just sort of walled itself out of this bill, and this bill is pretty much just applying to private entities, and not too many aspects of government collection, use, processing of data will necessarily have provisions of this bill applicable to it. I mean, I'm generalizing and making a fairly sweeping statement, but that this bill does leave you with a bit of a sense of that's how it may sort of play out.
Yeah, I would have to say I agree with you, Jalak. And to extend that a bit further, we've been talking about, access to personal data by the government, but there's also a very broad overarching provision in Clause 92, which leaves a completely carte blanche power in the hands of the government to make policy with regard to how non-personal data will be regulated as well. And while there is nothing really in the bill that either bounds or indicates how that power will be exercised, previous reports on NPD or non-personal data have shown that it probably will involve some kind of a mandatory sharing requirement. So yes.
Yeah, and I think, they're trying to save themselves, trying to say that, hey, we're asking for non-personal data that's sort of anonymized or de-identified. I think we have to really ask ourselves, can personal data truly be anonymized? There's still a lot of debate around that. The practicality of true anonymization and the challenges of even protecting de-identified non-personal data, you still need to have a lot of checks and balances in place.
Right, and I think the committee has actually acknowledged that in the report as well. So yeah. Absolutely. And that brings me to also this new sort of body that's sought to be created called a Statutory Media Regulatory Organization, which, coming to the other exemptions, including an exemption for journalistic purposes. Now, what those will be seems to be, the committee seems to feel that the existing Press Council of India, etc., may not be up to the task of regulating that. So they want to create this new statutory organization. But very interestingly, they've said that until that new organization is created, the government is going to prescribe rules in that regard. Now, again, that's a very broad power of the government to sort of regulate where media and journalism is going. And I was wondering if, Saikat, did you have something to say about that?
So again, I think that's very problematic because in a way, the one way to look at it is this is a carte blanche for censorship. Because if the government starts deciding that why should or when should the media be legitimate in accepting or agreeing to publish something and not access personal data, in a way the government is completely controlling the narrative, and which is very, very dangerous. And this is completely against the whole philosophy of the American Constitution and the First Amendment, where the founding fathers said that why do we need freedom of the press? The founding fathers of the American democracy and the Constitution were very clear that we need an independent agency which can inform the public, and the government can never be trusted to inform the public, because anything the government says, even if it is as innocent as it can be and whatever its intentions are as noble as it can be, it will always necessarily fall within the ambit of what we call propaganda.
Absolutely. So that's why the media is called the fourth.
And therefore, the media is therefore freedom of the press. By ensuring the government actually now gets to decide what the media can access and can't access, you are now, this is as bad as censorship, if nothing else is.
Yeah, so on the one hand, while there seems to be a broad power in the hands of the government to get access to all kinds of data, there's also, on the other hand, some sort of power over how data and information is actually communicated to the public.
And in fact, the whole idea of a constitution is to limit the powers of the government, because since we in a fiduciary capacity give them certain powers to rule on our behalf, the whole idea is that the constitution and its limitations will ensure that the government and its powers stay in check. You look at what the committee, in fact, the Joint Parliamentary Committee take a paragraph and discuss what the earlier Sri Krishna Committee had said, where the Sri Krishna Committee had very clearly said that if the government were to access citizens' data for national security, etc., there needs to be an equal or probably a higher oversight on the agencies which are empowered to take that data. So therefore, for intelligence agencies, there must be an oversight committee and certain laws in place. You now have a situation where the agencies which will access this data because of these exemptions, they don't come under any law. In the sense, for example, your intelligence agencies are all created through government notification. They don't come through an act of parliament, unlike other countries like the United States or the United Kingdom, where specific laws of parliament giving out the charter, powers, and limitations of intelligence agencies are clearly defined out. A, you don't have any acts of parliament governing them. Two, as a result, you don't have any direct oversight through parliament. And forget about parliament, even judicial. And one critical aspect of any access to data is, for example, American law and to an extent Indian law also recognizes that you will ask for legal interception of communications and data after you have exhausted all other means to investigate that person. And this is very clear in American law, and to an extent, even Indian law recognizes this. Here, there is absolutely no such requirement. And by giving a blanket exemption, any government agency which itself is not answerable to anybody will pick up the data, whether they have demonstrated any other means to actually investigate or figure out what is going on.
Absolutely, Saikat. And I think what that brings us back to the question of proportionality, broadly speaking, as Jhalak referred to as well. Are there any checks and balances at all to the exercise of this power, while there are certain broad conditions that are laid down in Section 35? It sounds like this panel feels that those will not be sufficient to really limit or check the government in how broadly it will exercise its power. Let's take some examples. Anushka, let's talk about the NatGrid program, for example, or Pegasus-style surveillance that's been happening. Do you think this bill will have any impact on that kind of activity? Do you think it will either in some way limit or curtail it? Do you think it'll enable it? What are your views?
So I think I'm going to break down that answer into two parts. Firstly, Pegasus, what it does, the way it functions, it's hacking. Hacking is illegal in India. You can't do it under the Information Technology Act. So, it's illegal. So the Personal Data Protection Bill does not talk about surveillance itself. So it does not regulate anything or does not make any changes or nothing has happened. Pegasus hacking is not affected by it because it is illegal. So we can stop thinking that it allows the government to do use the Pegasus spyware because hacking is illegal, so it can't do that. Coming to NatGrid, NatGrid is more interesting because it's our own government that's building it out. Whether NatGrid will be impacted by the bill, no, it won't be, because like everybody has mentioned, the bill evades any type of surveillance reform, and it goes further and says that in its long title, it says that to ensure the interest and security of the state. So this is a personal data protection bill that is flowing out of the right to privacy judgment. But in the long title, it says interest and security of the state. So the data protection law is seeking to, protect state security over individual privacy, and state security is one of its primary objectives. I understand that where national security is concerned, data protection rights cannot be absolute. I understand that. However, if there are to be such exceptions to individual privacy, these have to be limited and these have to be precise. Under clause 35, you just exempt the entire agency. That's so broad. So, what we needed from the Personal Data Protection Bill was that you define for what national security reasons will you hamper individual privacy, and it had to flow from what has been laid down in the Puttaswamy judgment. Nothing of the sort has happened. So NatGrid, the entire project itself is very problematic. It does not have any law of itself. It does not flow from any legal provision or standing act. We don't know if there's an SOP or anything else. And now the data protection bill has also spectacularly failed in terms of surveillance. So we really don't know how NatGrid is going to go forward. And the data protection bill is not going to help anybody of us. So I don't want to be defeatist or depressing, but that's how it is.
Right. So if we don't have much hope in the data protection bill and in how the broad framing of national security purposes, or really the lack of purpose limitations as applicable to the government have not been captured in the bill, how are other countries doing this? Is anybody doing a better job, and in what ways? So when foreign governments need access to data within their countries, how are they doing this better? How are they enforcing better, more proportionate standards? And can we learn something from that? That's an open question. Please have a shot.
I actually, when I was researching for this, I came across this interesting example of the United Kingdom's Data Protection Act. In that, the national security exemption does not extend to the entire act. It requires a specific certificate which has to be signed by a minister of the crown. Whatever their whole entire procedure is, and it can be challenged by the affected person before a tribunal. So they do have certain provisions. The GDPR, as a basic standard law for privacy, has certain provisions, and I think Jhalak is better placed to answer this question. But in terms of examples, there do exist a lot of examples where other countries are doing much better when it comes to data protection and surveillance.
Chalak?
So I think, Vanisha, what they do really well in other countries is, I think there are a lot of requirements in the law itself, which so I think firstly we have to say that privacy is not an absolute right. There are limitations to that right, and there are legitimate circumstances in which international jurisprudence has developed to accept that the state will access information about individuals, right? There are certain grounds that have sort of evolved where that access is sort of allowable. In different countries, those grounds are different. So there's national security, there's public safety, there's public order, there's security of the state. We've seen, various language that has developed globally. So one thing is the circumstances in which this access is allowed. But usually in most countries, there is a very clear sort of set of principles that apply. There are a very clear set of principles that apply in terms of, a very clear process that applies in terms of how that access can be granted, right? And the circumstances in which that access can be granted to government, the extent to which information can be shared with the government, who within the government that information can be shared. There are data minimization requirements, onwards requirements in terms of if one government agency has it, how much can be shared with a second government agency. There is the role of, very often of judicial actors in sort of sanctioning such a request. So I think there are various checks and balances and sort of requirements that have to be met at every stage in the process. And unfortunately, of course, the data protection law doesn't have that. It's basically exempting government agency from the application of any of even the basic principles of data protection law, which is not necessarily the case in other countries, right? Some basic provisions still apply. But I think, it's over here, we also, as Anushka just pointed out, we don't have even so when you have to interfere with the right to privacy of an individual, what is the first principle that Codifying lays down? That there has to be a law, there has to be, and we don't even have any sort of laws that govern this kind. We don't have laws which underpin we don't have laws that underpin frameworks like the NatGrid, right? So I think in such circumstances, we really have to think about how are we going to hold the government accountable around the access of information of individuals. I think one slight hope is the Pegasus committee that's been set up by the Supreme Court, which besides looking at whether what has happened in this whole incident, has also been asked to look at current surveillance laws and sort of hints at reform. So maybe that's the next step in all of this, but who knows how it's going to unfold.
I think you brought us to the very important question of government accountability. So while so to pedal back a little bit, we started out by saying in the broad constitutional framework, the state is accountable to the citizens in any democracy, and is the broad structure that's been captured in the chapter on fundamental rights in the Constitution as well. And this sort of seems like a departure from that, in the sense of a restriction or a departure. And like we've discussed, that needs to be proportionate. But really, where is the accountability then? Have we come to a point where really it's kind of the individuals in a country in India are actually accountable to the state because it is their personal data that is accessible at the drop of a hat to any exempted agency? There also seems to be only very broad limitations, or rather conditions on the fulfillment of which the central government can exempt such agencies. The extent to which such agencies can be exempted is also very broad, and this fair, just, reasonable language that's been incorporated into the 2021 bill, as both Chalak and Anushka, you all have rightly pointed out, is applicable only to the procedure, but not really the substantive exemption that is granted to the agencies in the first place. So, Saikat, what would you say about this question of accountability of the government? Like you're saying, in the past as well, even without such an enabling provision, we've seen through RTIs that there has been very high access to data by the government. In what ways could this provision have been better in order to sort of align a little bit with the accountability idea, in order to make it a little more proportionate when we deviate from the privacy right?
So that's an excellent question and something we've been dealing with for a long time. I also detect, there's a sort of note of sadness both when Anushka and Jhalak speak, and I can understand, and many of us like them have been battling this for a long time. It seems like it's a battle that's already lost. I would suggest that, don't think like that. We have to keep pushing and we have to keep trying, because if we give up, then who else stands this line? So with that, let me take you through some of the questions. Like, first of all, your last question was that are there any countries who are doing it right, etc. When it comes to surveillance, practically nobody in the world is doing it right, because it is intrusive, it gives tremendous power and information is power. So imagine the power that any agency has once they have information about you. So therefore, certain principles of purpose limitation, very narrowly defined and sharply defined, come into play, etc. Plus certain procedural things that can be done. So for example, what Estonia has done is an interesting example. If any agency in the government wants your data, there is a time limitation after which you, as the data principal, you have to be informed that such and such agency for such and such thing did access your data. When you at the outset in a country like India, it sounds very shocking. Oh, all the secrecy of our investigations will go. How will we combat terrorism if you have to tell a prospective terrorist, etc., that your data was accessed, therefore it was to be done. But you see, the beauty of it is, let's look at the Prevention of Corruption Act, where everybody, if a certain level of official has to be investigated, whether it's joint secretary and above, then everybody from their uncle and their grandmother have to be informed even before the investigation can take place. So from a bureaucracy point of view, they have protected themselves by saying, if you are going to investigate me, please inform everybody else before you come and even start the investigation. But when it comes to citizens, there is no such protection. So in our own law, actually for a certain class of people, a certain protection has already been put into place. The same principle. So even if it is for counterterrorism, which is, one of the biggest fears for accessing data and therefore intelligence, etc. At the end result of that data collection, there can be only two outcomes. A person is guilty, or B, a person is not guilty. That adjudication can only be done in a court of law. And if that is the case, that whether a person is guilty or not guilty, even if the person has now been found guilty, all the data, whichever was accessed, has to be brought to a court of law. So it should be mandatory that any data collected once actioned has to, within a certain time frame, end up in a court of law. So that will give you one major protection, because now the courts are there and you can see that you were under investigation, therefore you were under surveillance, therefore your data was accessed, and here is the data that was collected. So there is a court of law where that adjudication can be done. And two, if you are found not guilty, then A, there should be a procedure to not only destroy all that data, but also a certain action can be taken against the people who asked for that data and did not find that anything amiss came out of it. Moment you do something, a few tweaks like this, you will ensure that there is a third party which is now being asked to look into the data and also judge it by the merit of whether this actually helped for the allegation or for the investigation that it was purported to be, therefore making it necessity, therefore bringing in proportionality, and therefore bringing in legality.
Sure, Saika, thanks for that really hopeful note. And for sure, that is the framework that Puttaswamy reiterated. Unfortunately, I think the concern is that I don't see that reflected really in the bill, and please correct me if I'm wrong. For example, very recently when UHID IDs were assigned to individuals who signed up for vaccination, it's been reported that that was done primarily without consent. So where data is being sort of collected as directly as that, and it could be in less direct ways, for example, requisitioning it from other companies or other agencies of the government, what recourse does an individual really have? One way is, yes, to approach the courts and use broader general principles relating to privacy rights. But again, does the bill really
no, that's what I'm saying. That's my point, that right now there was the bill, then it went to the committee, and now it's gone back to the government to again look at what the committee has. So we still have space, we still have time to actually make that point. And as I mentioned that, so how do we find an answer to this? While there are much bigger problems to deal with, just ensuring through the bill that any data that is accessed, especially for criminal investigation, or as the bill beautifully says, any crime that is cognizable as defined under such and such section of the Criminal Procedure Code, then any material ever accessed, that agency has to go to a court of law within a stipulated period of time. If that takes place, then the agency will have to think twice before they access any data. So that tweak can still be done.
Right. Any thoughts on this, Anushka or Jhalak?
I think what Saikat has mentioned is really hopeful. And if we can actually have that, I think that would be perfect. Right now, the bill, as it stands, again, I'm going to go back to discussing the bill because that is what we have right now. So if something like that happens, you go to the Data Protection Authority that is under the bill. That's as Jhalak has mentioned, accountability issues with the Data Protection Authority, independence issues with the Data Protection Authority. So if you go to that, you may get something out of it. If you don't, then you go to the Appellate Authority, also under the bill. Again, that authority will also be constituted by the central government. So, you really don't have that much leeway. And then you can go to the Supreme Court, like Saikat has mentioned, that, maybe we can do away with the DPA and the appellate tribunal because they're not independent, basically. So what we need is a strong, powerful, independent DPA, which will act as a actual regulatory body for the bill. Other than that, let's look at it. So under clause 14, it says that you can you can process data without consent. The state can process it without consent. Then under clause 35, they can exempt the authority. Or under clause 85, they can say that even if the government data fiduciary is not exempted and they have done something wrong, they will still be a judge in their own cause because the government head of department is going to investigate what has happened, and then they will decide the liability. So there are a lot of processes in place that you have to go through. Either they have taken it without consent. So how do you even know that your data is there? Then if it's exempted under clause 35, what can you do? It's exempted. If it's under clause 85 and the HOD is involved, then they do the liability. Then you question it before DPA, then you question it before appellate, and then you go to the Supreme Court. So there's a lot of steps to take before you actually will get justice, if you get justice eventually. And the process itself will be the punishment in this situation, I feel. So as we stand currently, it's very problematic, but Saikat is right. This is not the law that has been put into place. So probably, hopefully, we can have better provisions. But if you look at how the development has happened from 2018 to 2021, we've had a dilution of rights, and nothing has been strengthened actually. So if it happens, then I agree, it's going to be great. But little hope there. But yeah, we always have the courts. So we do have a judiciary to fall back to in that situation.
Yeah, and that's placing a high burden on the judiciary, and hopefully it will live up to the task. In the meanwhile, I think, as was discussed in the previous panel as well, maybe if the DPA were to be expanded and have more benches, of course, with more independence, not just in its functioning, but also in its constitution, I think that is something that is very, very required under this law. And I think India's one of the few emerging like larger economies which actually doesn't at all have any sort of a data authority yet. So absolutely that is something to pick off of. Any last thoughts before we open up to questions? Chala, would you like to say something?
I think, Manisha, just one more thought. Like when we talk about the DPA as a regulator, I think there's been a lot of emphasis on independence and accountability, which is of course core to any regulator. But I think there are a couple of other things we need to keep in mind. One is competence and capability and capacity, which comes from technical expertise on one hand, which is of course always more challenging as a new regulator set up in a relatively newer space. But I think another component of capacity is sort of the financial sort of capacity at the disposal of the regulator, and whether they have, you know, the structures and systems in place which they will need finances for to really operationalize the DPA. So while the, you know, I think that's a really important point, and that's something that's also come up in the context of the GDPR and reviews of the GDPR. And we're talking about the GDPR here, where there is quite a bit of, you know, financial allocation and other forms of support to enhance the capacity of the regulator. This has been consistently one of the points highlighted, and this has been one of the criticisms of the GDPR, is the regulator doesn't have enough capacity to really tackle the issues, because on one hand, they're dealing with like large corporations, on the other hand, they're dealing with the government. And besides accountability and independence and transparency in the functioning of the regulator, you also have to really highly capacitate the regulator. And I think that's an important point in all of this, is if the regulator has to hold, you know, government accountable in any way, they also have to have the capacity to be able to dig through, investigate, think through, put in place codes of practice, rules, regulations, you know, that as sort of required. And I think the second point that I just want to make as we close out is, you know, in Puttaswamy 2, one of the things that the Supreme Court sort of did do is they sort of struck down government access to sort of bureaucrat access to Aadhaar details in certain circumstances, right? And the bench really expressed a hesitation over there and said that, you know, there should be inclusion of a judicial officer around such access. So when we're talking about government access to data, I think that's sort of one point to sort of keep in mind, that there was hesitation from the judiciary in Puttaswamy 2 that we have seen, and, you know, that needs to sort of be kept in mind and drawn out and sort of built around as we move forward in this conversation.
Absolutely. I think those are both very, very relevant points, Chalak. So it's not just about independence, but it's also about competence. It's also about ability financially and otherwise. It's also about how much the judiciary can and should be expected to do, and what the trends have been. It's very important to read the law, right? Not just in terms of what's been said, but also what trends we have seen. And so thank you all for being here. Thank you for bringing up those important points. And I see Nikhil has come online. Nikhil, are there questions from the audience that we should be addressing?
I actually had, you know, one, and I'm sorry if this has already been addressed, but one of the things I remember from a conversation with the founder, and I bring this one up often, is that they basically get calls from government departments or agencies that want access to their data, to all of their data, and then they send lawful notices for specific data. Is there anything in this bill that empowers companies, gives companies protections against that kind of an activity from government departments? So they can pick up the phone and just ask and say, okay, give us access, and or just turn up at an office and say, we need to look at your servers. I mean, a lot of data center businesses actually get harassed quite a bit.
I don't think there are any protections. I think under the SPDI rules, I think they had to submit specific requests. But now I think this bill allows agencies to actually ask for data, because if you apply the clause 35 exemption, then and under that, for example, if the Delhi police makes a request to you, what on what basis will you say no to them? Right? It's the Delhi police that's asking you, and if it's a national security issue, is what they will claim.
Or let's say it's just for investigation.
Yeah, any investigation for that matter. They don't even have to disclose the reason. If it's an exempted agency, it can do pretty much anything. It does not fall under the law to stop itself from doing anything like that. And in clause 35, processing also means sharing. So if you've shared it with one agency, that also means that you've basically shared it with all exempted agencies. So there's literally nothing stopping the government.
What about non-exempted agencies? If, let's say, an exempted agency gets it, what prevents them from sharing it with a non-exempted agency?
That's a good technical question. I'm not sure if it's an exempted agency, they can share it. And the non-exempted agency is just receiving in this situation, right? They're not sharing it further. So the purpose limitation and the storage limitation, I think, applies to them still, hopefully. So it should not be a problem for them to receive the information. If I'm thinking about
but
it,
they also don't need consent to get access to that information. So it's non-consensual processing.
Yeah, just to add to that, Nikhil, I think the power under 35 is just very broad in terms of what the central government can specify by order. So it's kind of delegated that whole substantive power to that order that the central government will sort of issue. And that can literally specify the provisions from which there is exemption, the agencies which are exempted, and the manner in which that agency can exercise those exemption powers. So, depending on what that order looks like, and, we apprehend at the worst that language will be just extremely broad. In that case, then, that will affect the sharing. And say if that order contains exemption also from consent provisions where sharing is concerned, then the agency that has collected data would not be bound by consent requirements when it shares even with an unexempted agency. And that's the issue really. But just to add a small hopeful note to that is also no rules have been framed yet under this law. So I don't know if that to any extent, again, at best it can cater to that sort of fair, reasonable procedure. But yes, the substantive aspect of this power is very broad, and there's no taking away.
So let me just change the framing now. This is at the central government level, but as we know, a lot of activity happens at the state level. And I recall when this bill was, when after the Sri Krishna committee had submitted the bill, there were these news articles about how Delhi police in particular had sought lots of exemptions for the police under this bill. So what happens at this, and I know Delhi police is not governed by the state, but let's say, let's take Telangana police, which is fairly active in terms of, collecting citizen data. We've seen them put up tablets in front of people's faces and do facial recognition. Is any activity of that kind prevented, especially since they're not taking consent to, there seems to be no probable cause, and I know unfortunately we don't have a probable cause standard, but anything that restricts state agencies from collecting and processing data under this bill?
I'm going to jump in here again. So clause 14 says that you can collect data without consent for reasonable purposes, and reasonable purposes includes security reasons. So, and it does not make mention of central government or anything. It just says that the authority can do it. I think again, as a data fiduciary, which means that as the authority which is going to process, if the data fiduciary thinks or is of the opinion that it is reasonable purposes, then they can do it without consent. How that plays out in front of the DPA and the appellate authority, I think could be interesting. But I think clause 14 does provide for them to do it without consent in any situation, because reasonable purpose can be literally anything. So yeah.
So as someone, let's say, who feels that they've been unnecessarily, let's say, if there are flying drones and they capture my footage and run facial recognition on it, what rights do I have as a citizen? Where can I go? What's the process that I can follow? Because this reasonable is a very questionable sort of term, right? It can always be challenged whether this data collection and processing was reasonable or not.
Again,
so do I go to the DPA?
Yes. See, here the issue is that first of all, nothing illegal has happened in that situation, because facial recognition is not regulated, nor is mass surveillance. So nothing technically illegal has happened. Right to privacy has been violated. That's a constitutional thing. So you can go to the DPA. I would think that it is better, and that's what we've tried to help the person in Telangana with, is that also because there's no DPA right now, but you directly go to the court. So, IFF has filed in the Telangana High Court against facial recognition, which is happening currently there. So I think it's a better route to take, instead of saying that what the data fiduciary has done is not under the bill, because facial recognition itself is violating privacy. So, directly we've gone to court. But yes, if the bill does become law, then you go to the DPA for any type of, if you think that anything has happened which is wrong, as far as I understand.
And to that extent, I think it's very interesting, does the bill, by bringing in these procedures where you first write to the data fiduciary, then if you're not satisfied with their response, then you go to the DPA, which can then refer your complaint to the adjudicating officer, and then you can appeal to the appellate tribunal, and then finally the Supreme Court. Are we actually making it more cumbersome for an individual affected by a privacy rights violation than directly approaching the courts under Puttaswamy and the broad constitutional framework? So is it actually impeding the enforcement of the right than when we don't have a law at all? What do you feel about that? Saika, Chala?
Oh, absolutely. I mean, without doubt. For example, let's look at it, compare it with another law, which is the Right to Information Act, which is supposed to actually bring transparency to government. And you see how the Central Information Commission and the pendency of, etc., the first appellate authority, they're all completely broken. So a law which was supposed to help citizens access data of the government, which is actually their own data, there you have created such a huge problem that you don't for months hear from the first appellate authority. As a result, you can't go to the Central Information Commission, and even if you go to the Central Information Commission, it'll be probably years before you get heard, and then by the time you land up in a High Court or a Supreme Court, you've completely run out of steam. And they have done exactly the same to ensure that when it comes to protecting our data, the same cumbersome, etc., is done to ensure that we will never be able to protect ourselves as it was supposed to be or meant to be. And worse, here you are also creating a DPA which will live at the mercy of the government in power. So as a result, you are creating a hire and fire agency where you can do whatever you want, you can appoint whoever you want, and you can then fire them whenever you want, so that they always toe whatever the central government tells them.
Right. I think it's very interesting. It's apparent in this bill to me, as well as other emerging legislation, where this idea of public interest is more and more being conflated with the idea of state interest, right? So as opposed to the constitutional scheme where we used to look at the state being again accountable to the public and having to answer to what is better for the public interest. It seems to have kind of been usurped by the idea of state interest, and state interest is actually a term that's used in this bill, which I've seen for the first time, and been conflated very, very obviously with the public interest. I feel that's quite problematic, and I wonder if any of you have any matching or opposing views on that.
I mean, I think Manisha, it goes without saying that that is a massive issue, right? I mean, if you look at the ethos of the Constitution, it is basically safeguarding public interest, safeguarding individual rights. And of course, state interest very often is in direct tension with public interest or with the protection of the rights of individuals. So I think it goes without saying that it is hugely problematic that those two ideas have started to be conflated. But coming back to the question of whether, the setting up of this process through the data protection bill, of the authority and then the appellate tribunal and then the high courts and the Supreme Courts. I mean, if you go back to, regulatory theory and design in terms of why we've started to see, these regulators being set up, and there's a lot of questions around whether that's the right way to go. And, you're sort of centralizing three different kinds of functions: executive, judicial, and sort of legislative functions in an authority, and whether that's the right way to go or not. And there are those sort of fundamental questions, but I think it finally comes down to sort of implementation and independence. So if I don't think we would be having these kind of conversations if tomorrow we felt like the regulator was truly independent and had the capacity to sort of implement, right? Because if it was a truly independent regulator, it was a really independent, robust appellate tribunal, they would be able to implement the spirit and the letter of the law, as sort of laid down in the data protection bill, which, at whatever point it becomes law in whatever form, as well as sort of the rules, regulations, codes of practice that are sort of evolved under the data protection law. And you wouldn't necessarily feel like everything has to go up to the High Court and Supreme Court. I think in India, the default is that we feel like we'll only get justice when we reach the High Court and the Supreme Court, which is really a systems design, a regulatory design, a sort of implementation capacity issue. And I think it then just brings us back to the question is our default for everything going to be that we will only get justice, or, we will only see right happen when we are able to access the High Court and Supreme Court, and how much burden and expectation can we place on that pool of judges to make this happen? Because after all, I think one of the ideas with moving towards regulators, and again, there's a lot of questions around whether this is the way it should be done. There's a lot of questions around the way regulators are set up and the powers that they are given. Is the fact that these are very specialized domains, and you want to take them, you don't necessarily think that the judiciary will be the right place to debate the nuances of the application of certain data protection principles, and you want sort of expertise and depth in that particular domain to navigate the complexity of those issues. So do you really need all of that to go into the courts or not? I think is really a question we have to ask ourselves. Yeah.
I think that's an absolutely fantastic point, Alak. And, it really brings to the fore that if we're going to look at the High Courts and the Supreme Courts to finally deliver justice, even in data protection matters, which, as you said, is considered to be a very specialized domain that is getting even more specialized as we go forward, and even as big data becomes more and more the norm and we go into, the metaverse kind of places, then why even have a DP? Even if even at the very threshold, when we're discussing it at the level of a bill, when it's not even a law, if we have so many doubts about its, not just its independence, but also its capacity and ability to function towards the very basic tasks that it's been assigned, then really are we just paying lip service to that? So I think that's absolutely a very foundational question to consider. The other thing that I was thinking is, the bill draws a distinction between the idea of exceptions and exemptions. So while consent is the grand norm, is the foundational framework upon which data is to be collected and processed by all data fiduciaries, whether they're private or state actors, there are exceptions, right? So there are reasonable reasons, like we said, under 14, there are employment related reasons, there are Section 12 kind of exemptions for the state, or welfare benefits provided by the state, which has been critiqued in itself. So then where is the reason, where is the sort of need at all for these kind of blanket exemptions, where you're not even considering consent as a threshold requirement from which you're sort of making a carve out, but you're saying right from the beginning that we're not going to be regulated at all. So it's kind of like saying that the right to privacy doesn't even apply against us at the first instance. And to that extent, I feel it's problematic. Yes, Nikhil.
So I had, maybe it might be a silly question, but does the right to erasure or the right to be forgotten apply to non-exempted government data fiduciaries?
Yes. Data fiduciaries has been very broadly defined to include both, to actively include state. The word state is actually there in the definition of data fiduciaries.
And so therefore, the right to erasure, if someone wants to expunge a record from a government data fiduciary, does apply. And
yes,
that might lead to some very interesting use cases and situations. I can see Saikat smiling at that.
But I think we can also probably agree that at the very least, the name of the data bill should be changed. It should not be data protection bill, but we should call it data access protection bill, with the intention to protect any means to access data. So I think that basic change should be effected in the current state of affairs.
I think that's a headline right there, Saikat. But there's a comment from Varun in the Q&A. It says that a connected, I think maybe in response to something that was said earlier, said that that clause 12 on processing by the state is also cited in clause 8 on the quality of personal data, where the phrase prejudice the purpose of processing under clause 12 is fairly liberally used. So is this not just about non-consensual processing, but also about other obligations and principles not being applicable? Anyone?
Nikhil, if I'm not mistaken, I think that question was with relation to the previous panel on the DPA.
But it also does cover the state, so I was just wondering.
Having said that, if any of the panelists have a view on that.
But it does cover processing by the state, so that's why I thought I'd ask.
So, I mean, basically, you know what's happening with Aadhaar. The Aadhaar photographs and other data with Aadhaar that's there, it is exclusionary. So, you can question the quality of that data. But if the exception under clause 12 is applied, that it's being done for the exercise of a function of the state, that means that you don't even have to keep the quality of the data updated, if I understand the question correctly. So, I mean, yeah, it does end up questioning the entire act and the purpose of the entire act if the data that you're collecting is also not up to the quality. Then it will definitely lead to exclusion. So why are you even collecting it? Because data collection by the state is for providing benefits. So if the data quality is so abysmal that you can't provide benefits, then what's the point? But still, clause 12 says that if it's for the exercise of any function of the state, then you can do it without consent, and that's what they're doing. I think, kind of.
I think just before we close, Anushka, I was just wondering if, and I know Saikat in a sense mentioned his wish list about how he would want surveillance reform, but everyone just want to do a round of what your wish list might be. Anushka, starting with you.
Yes, definitely. Regulated access to data for the government, surveillance reform, and definitely DPA, a stronger independent DPA. I think those three are
But
very
just
important.
in terms of government, on the government front, any specific changes that you'd like to see?
I think Clause 35, you cannot exempt entire agencies for the entire function. That's very problematic. Clause 85, you cannot have a government data fiduciary, any offense that they commit, be treated differently than an offense that is committed by a private actor, because it creates two recourses to justice, and it's basically just against equality. So yeah.
Jhala?
Sort of echoing what Anushka said, but like one thing specifically is Clause 35 should have necessity and proportionality as a standard.
As you said, everywhere where it says necessity, it should also include proportionality.
Yeah,
right?
because otherwise, because proportionality is really a key component of it. It's to what extent you can access it, how much you can access, for how long you can access. So I would say that's one big one. And I think to me, and in the data protection bill, the new version of it, they've sort of hurriedly brought in the whole non-personal data aspect of it. And one of the things that sort of is, I feel like they haven't thought through how it comes in at various parts of the bill, so it's a bit patchy. But one of the things is, it seems to be that the central government is going to make rules around non-personal data, and the role of the regulators not necessarily very clear. But at the same time, if you look at the provision on non-personal data, it says the government, in consultation with the authority, can sort of talk about accessing certain kinds of de-identified anonymized data from certain sort of entities. So it's a bit in the gray in terms of that kind of government access of data around non-personal data. How is it going to function, and is the government only going to create the rules for its own access, and the authority has this very limited role of consultation? Because that's a whole different Pandora's box of data that now the government sort of will be able to access through this law,
which will lead to a lot of IP related issues as well, I suppose.
Absolutely.
Saikat?
So I think the dissenting notes in the JPC report are very interesting pointers in the kind of reforms or changes that should be there in the bill. One, of course, is 35. Both Anushka, Jhalak, and Vanisha have been quite eloquent about what the problems are. Dr. Amar Patnaik and Manish Tiwari also makes a very important point in his dissenting bill, that the same law cannot have different standards, one for the government, one for the private sector, heavily regulate private sector access, but give a complete open gate to the government. That again is problematic. That's like very poor lawmaking.
Well, as always, he also does say verify all users, which is his thing.
Exactly. So as I said, at some point there is a discussion on accessing data without that protection, etc. But secondly is that what Dr. Amar Patnaik has again pointed out, a very important thing, that a lot of, because of the constitutional scheme of things, there are a lot of issues which fall purely within the state, like health, education, etc. So the bill completely fails to recognize the role of the states and the subjects which are within their jurisdiction. And suddenly now you will have a central government and a central DPA having access to information. Even from an operational point of view, I don't know how this will be accessed, how this will be enforced, because you have a district collector who's sitting on tons and tons of data, and suddenly a central government authority to a district collector, say in Odisha, will say that you should give out this data, so on and so forth. And that just does not fit within the constitutional scheme of things. So that's something that really needs to be looked at. And yes, we need to go back to our principles of data protection, where if any data is to be accessed, then it has to go through purpose limitation, but also accountability for what you did with that data.
I was just thinking, look, your comment about it being called a data access protection bill. Perhaps we should sort of, put in a snarky sort of a note saying, call it this, make this open, because that's what you want to do anyway. So, why even have any semblance of protection? I think perhaps ridicule is the only form of response that might work over here. Vanisha, your wish list.
Well, I really like the points that Saikat just made, and of course, what Chalak and Anushka have been saying as well. And not to repeat, just the fact that Section 35 altogether is way too broad, and really, I don't see the justification from a proportionality standpoint for an exemption clause at all, given that we already do have a chapter on exceptions already. Having said that, if one were to give up that first line of resistance and accept that there will be some sort of mandatory forced non-consensual access to data by the government, at the very least, I feel there should be information provided to individuals whose personal data has then been accessed. So I should at least know who has access to my data. And secondly, this is a very, very basic point, but honestly, because we've been advising clients on the upcoming bill, I think just a little more clarity in the language of such provisions, given the extent of access and that they enable. The fact that this exemption actually may translate to an obligation or a mandate on companies to disclose data that these government agencies demand of them has been provided in an explanation, a second explanation to this clause, which says that government agencies might be exempted. So I think if that's the intention, then let's make it clear so that it's easier to push back against, if nothing else. So this would be my short.
Perhaps purpose limitation and specification applying to, like what I think Saikat is saying, to government access to data as well. Great. Thank you all for a great session. I know this was an intense session, and this is a topic that, I don't know, maybe if this bill passes, and maybe if the Pegasus cases force the Supreme Court to mandate to push the government to perhaps create a law for surveillance reform, we might actually have a separate law for surveillance reform that might override this bill as it comes out. Or maybe in this last change, looking at how the Pegasus case is going, the government might scramble to put some limitations to maybe create a situation where the court doesn't push it to create a law for surveillance reform. I don't know, but this is all very political from here on. Let's see how it pans out. But thank you so much, everyone, for joining, and thanks for everyone who attended. Thank you for joining us for day 2. If you want to revisit the stream for today, it's on MediaNama's YouTube channel. Yesterday's stream is also going to be there, and I know a lot of people who've gone and revisited yesterday's stream today. We will also be writing about this, all of these sessions on MediaNama. We're going to submit a wish list to Meti as well. I don't know if they want one or if they're expecting one, but we'll do what we can. I'd like to thank ADIF as partners for this discussion, and Google, Flipkart, Meta, and Star for the support for this discussion. Before we close, just a quick reminder, next month, for MediaNama members, we'll be doing a talk on the state of tech policy in India, giving an overview of what all changed last year. So if you're not a member, please do subscribe. We'll also be hosting a discussion on non-personal data somewhere between the 16th and the 20th of next month. We'll be in touch. And through the year, we're going to also host discussions on competition, content regulation, crypto, and the metaverse is something that I'm really interested in. And of course, we're going to do PrivacyNama again in September. So if you'd like to support or sponsor any of these discussions, please do get in touch with us. Thank you all for joining us, and thank you for these last 2 days. Thanks. Thank you.
Thank you. Bye.
Bye.